Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 20th, 2020, 7:44 p.m. How does the FBI find people? The people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I guess you know who you are. Welcome. Come on in, take your seat. We have a fun afternoon lined up with hearing from Bryan in Bryan Kohberger's case, which he always attends. I don't think he's missed any hearings, ever. He's like, his attendance record is A+ when it comes to his case. Let's see. Where do I need this one? I need this one down here. Need it on the other screen. Oh, that's not it. Where'd it go? I thought I had it, but I didn't. There we go. We're going to get Bryan Kohberger ready to go over here. Is it not pulling up the way I want it to? Welcome back, by the way. Let's do a big shout out, first of all, to, you named it, Britta Aller. Britta Aller, congratulations. First in chat today. It was a bit of a rush there at the end. I forgot I had not made a thumbnail. And my mods start texting me, when are we coming back? I'm like, did I not? Oh, no, I didn't. I guess it's a legitimate question. We are back. We're back. We're just getting ready for Bryan Kohberger to begin. So let's see. We've got why it doesn't want to work properly. YouTube is being stubborn. Okay. Which will force it to work right. Why is it not showing me accounts? Sorry, guys, I'm busy. My brain's busy. Brain's full, can't talk. Okay. How you guys doing? How's everybody doing today? Good? Bingo. Finally, it hit it way down where it didn't belong. Okay, I've got it pulled up. That one's good. Was hiding. Have not looked at chat, so I hope people are here. I hope I'm live. Looks like we are live. Welcome. Airbnb verdict will be streamed this afternoon. That's the plan. As long as everything goes according to plan, we'll be there with that. Let's see. That starts at 2 o'clock, so that starts in an hour. I do have a frosty water bottle. It's cold, and it's because it's hot in my office. It's too cold to guzzle. It's really chilly. So we do have the sentencing today for the Airbnb duo that were tried together. Both found guilty of various charges and not guilty of others. But the sentencing is today. That will be after the Bryan Kohberger hearing, which we're just waiting from the court to get audio to. Let's see. Let's reset that. Just waiting for the live stream. The one problem with this judge is he hits the go live button on his live stream right as he says, now calling the case of. So there's zero lead time. Zero. None. Nada. Zilch. So we basically get no lead in or miss the first half of a sentence as long as we click refresh about 1 billion times. But we'll do that. That's my job. That's what I'm here for. As soon as that pops up, we'll be there. It should happen in the next probably 10 minutes. How many times do I have to click refresh in the next 10 minutes to get the feed? I don't know. All right. Don, oh my goodness. Yes, the treadmill one. Is that the treadmill case? If it's the same one, that's a really tough case. I can't watch that one. Yes, I'm sorry. Reverend Beasy, you're correct. I keep saying verdict. The sentencing is today. Verdict came in before. KR's over in time, just in time for BK. That's a really tough case. I mean, that's like I'm not going to sleep at night type thing. It's horrible. Your heart aches after watching that. Of course, there are other equally heart-aching ones that we do follow. So it's weird how we make those decisions. Just waiting for court to begin. What are you guys looking at? Oh, me. Hey, how's it going? Let's see. What else is happening today? Karen Reed just ended testimony for the day. Did they have any motions or arguing outside of the jury presence today, or are they all done? I know they work half days, which is weird. I want that schedule. BK Trail is going to be awful. I don't know. Ronnie, what I think right now is with regarding the BK trial is it's going to be a lot of unknowns and blanks, and we'll have ME information. We'll have the speculation as to what happened, but unless we have testimony from the one surviving witness that describes what happens, I think really we just have the end result. We don't have anyone describing what happened. They'll just try to piece it together, and it's going to be the best guess. But honestly, they don't need to know exactly which steps he took where to prove that case. So I will say that we've seen, Mods made me aware of on some other channels, I think over on Facebook, that there's an individual who's posting as if they are Ann Taylor and saying, hey, reach out to me, and providing the email address. Here's my take. I believe that is not Ann Taylor, but they are giving Ann Taylor's email address, which results in Ann Taylor getting spammed with email from people who think that the defense wants their help on the case, and they are not seeking it. Ann Taylor is a fantastic lawyer, fantastic public defender. She's currently a public defender because of how this all went down. Fantastic lawyer. She has great resources available to her, and she's using them. She probably, if you think this one through, she probably is not trolling Facebook chats looking for valid defenses to use in a murder trial. That's just my take. It's probably not her. That being said, I do believe from the information I've got that that the email address they're providing is hers. It uses the right format. It matches the format of other employees also working out of the same office. But that's just heads up. I don't get sucked into what might be a scam, really. Ann Taylor with an E is Bryan Kohberger's lawyer. She's very good. She's the blonde-haired lawyer that you'll hear from or see here in the hearing in just a moment when we go live from Latah County. A couple decisions still hanging out there. The big decision in this case that's hanging out there that we're waiting for is, of course, the venue ruling. Venue being the location of where the trial is held. Typically, courts the court you attend in a trial is in the county where the crime was committed, but you can petition for a change of venue, file a motion for a change of venue if there's legitimate reason to move it, and then they will move it to another usually a neighboring county or something close that way. So that most likely, I'm talking 95% chance, is going to happen. They already have assembled enough data to justify the move. The only part we're waiting for is the other data that shows where we're moving to see if it's a little better. And odds are it's going to be a little bit better, or it's going to have a larger pool to draw from that will be easier to get a seat of jury from. So that's going to happen, but that doesn't happen till what, June? Middle of June? Maybe it's June 27th, I think is that date. So let's see. I have to keep clicking refresh. Don't let me forget, or else we're going to miss 2 or 3 sentences. Is her email public information, though? No, it's not. It's actually not listed on the website. It's the Kootenai whatever. I don't remember. It's a strange county name. It's the Casey. It's a Casey. I forget. I don't remember the email address off the top of my head. But if you go to that domain name, which is the last part of the email address, it is actually it is the proper website. It does have a directory, and you can look at other employees that work out of that office. Ann Taylor is listed as an employee, but her email address is private. It's not shown there. Other employees, it does show their email, and if you can use the same setup with the first initial, last name at that domain address to find their email. It's very common in business to use it that way. So with no other Ann Taylors located there, that's probably the format for her email. Anyway, don't try to share them around. We're going to delete it if it happens over here. There is a small chance that it is Ann Taylor out there just trolling the internet for help in the defense case that I think she's very well qualified for, but I really doubt it. It's just when you see some of the stuff that's out there, realize there are some people who just are trying to get attention or cause problems in a case. Let's not find ourselves in either of those groups. Haven't missed anything yet. We're waiting right now. Kootenai County, that's it. Kootenai.
Are we going to address subject matter jurisdiction?
Probably. Judge Boyd just had to separate 2 adults kissing and hugging in court. Oh, man. Okay, here we go.
Is participating remotely. For the state, we have Mr. Thompson, Ms. Jennings, Mr. Nye is participating remotely, and I don't see Ms. Beatty. So we have a few things just to sort out today. The first thing I want to talk about is whether or not this hearing should be sealed.
They might shut us down.
What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms. Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's
they're going to kick us out.
The challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out into the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated and may be prejudicial to one or the other. So I guess at this point, we'll keep this open. Thank you. Be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair, and we'll have determined
legal advices. Thank you so much. Thanks for the
in
read.
Advance. Okay, so
we have Broken Bakers in here as well. Appreciate both.
Keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that.
I'm going to file a motion to straighten the camera on the left. That's driving me nuts.
I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order, and so that one's appropriate to close.
Okay. Okay, I think I'm on the same page. But great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident that when the court does this same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124, subsection B, and Rule 32, subsection E. And it would disclose investigative techniques or procedures which are exempt, pursuant to 74-124, subsection E. For defense's fifth motion to compel, Item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104, subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32, subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, Subpart A, names a private business and is exempt under the previously cited authority. Item 2, Subpart B through L, deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3.
Thought she was going to sing the alphabet song there.
Deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
That's tomorrow.
Right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge.
She might let things
Our
slip
discovery
here.
requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information, it isn't, it seems anyway, I mean, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency in saying this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us, that is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
She has a strong argument.
Taylor. You know, I don't know where did it stop though. I mean, if we start pulling out all the potential evidence for the trial before the trial, then does the state get to respond to that? And that's where does it start? I mean, it or stop. It just is a roll of that. And so either side, okay, that it sends to the public that it is not, you don't get the context. They don't have the context, the public. You have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they've disclosed, certain things, and it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like this isn't about the discovery, this is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine. And I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argument and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing,
pause for dramatic
this is your
effect.
order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheath. That, I'm sure, benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of...
That's the thing. I don't want to talk about those particularly.
The drive test.
I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IDG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about there's a lot of stuff, okay, that you're arguing about, and the state is arguing about, and I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues, Your Honor. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the cast report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, Deuces take them to the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, we can maybe address that today too. I don't think, thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that, and from what I've seen, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th, is the timing of these things, right? Not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you.
Oh, another ask. Sorry, I misheard her.
Are you expecting to make the decision right now? Maybe not.
Yes, please.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Yes.
Oh, 2 weeks, is that right? 14 days?
We're less than 2 weeks. We're 12 days.
All right, well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing.
Bummer.
Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues. All right, so let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you've had another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Right.
And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th. For disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10th is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. we'll deal with the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm gonna have really more, I'm gonna need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits.
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because we also have other things to do, but Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. Names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and I guess we've said it before. It is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
Your Honor, I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses on that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. we have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what that they felt they had to file a motion to compel on, instead of being patient and wait, because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say, that doesn't exist. So, I don't know what we're supposed to do at that point, and we'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I could give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Oh,
that's there.
You know what? Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you, okay? Your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want y'all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues.
That's right. We're happy to. And when we get the CAST report, we'll disclose it. If we do not have it, we are not withholding. As simple as that.
I read that last night. Okay. I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration. And it's a big deal. It's really important. I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th and probably at the 16th too. Okay. Moving on. We've got all right, some of these pending motions, there was no request or no response from the state. And I'm thinking that, the motion to unseal parts of the IGP, materials and motion to allow defense investigators to review the IDD, materials, that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's the state's understanding. Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just wait until
calendar.
the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything this day. It can read your mind sometime, maybe not. All right. Okay, I'm going to sign those subpoena duces taken. The FBI. I believe that's related also to the 13th supplemental. Maybe I'm kind of losing track of it.
Your Honor, it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great. All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week, and the court can vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just reset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that, I don't know, one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know, maybe you are having good communication with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably.
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon would be fine for the state.
Do you think twice a month? It's probably gonna ramp up.
It's going to be weekly.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress; those will come later.
Okay. Maybe we'll start with twice a month to get through all this discovery. I mean, I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all and have a good day. Beautiful day. Thank you.
It's a beautiful day outside, he says to Bryan Kohberger, who's going back inside, has not been outside since he was arrested. That concludes the hearing for Bryan Kohberger. We are about to jump live to the sentencing, which is about to begin for the AirBnB trial. The two defendants who were just found guilty in the out of Georgia, Judge McBurney's case. We're going to jump to that in just a moment. I've got that pulled up. We're ready to go. Very quickly, just a summary on what's happening here. Bryan Kohberger is accused of killing 4 college students and doing so with a knife. It was all over the news. It was everywhere. There was a huge search for him. The way the police handled the immediate aftermath of discovering that murder put everybody on edge. I think they handled it poorly. It got a lot of attention to the case. A lot of people were, involved and wanted to know what was going on, but it was. I think it was just done poorly. That's it. It was just done. It was done poorly, and people sort of watched from there on. We followed the transfer of Bryan Kohberger from out east with his parents' house back when they flew him in over to Idaho. We followed that air flight, and we've been following the details of this case as it's developed. Lots of paperwork. The defense here, what they're doing in this motion, is they want the opportunity to tell. Let me jump over here to tell people that. That they're not getting what they want. The state is not being fair. The state has a weak case. This is a chance to put something out in the media that makes Bryan Kohberger look better. Literally, they want to influence the jury that way. Our defendants are just walking into court right now. We're jumping now in this trial. This is the trial of the accused in orange. We call him the accused because he wanted to be called that. His name is Mr. Pritchett. Mr. Robinson is the other defendant. Mr. Robinson had lawyers. Mr. Pritchett went pro se and also went sov sit at the beginning and then sort of deviated from that. Just said pro se throughout it.
Oh my God.
But we're here for sentencing today, which is done by the judge.
Good afternoon, everyone. Ms. Rivers, are you able to hear us?
Yes, I can. Good afternoon.
Afternoon. Ms. Nelson, if you could check with pretrial services and probation to see if they'll be plugging back in. We're a little after 2, and I had asked them to rejoin us.
Okay, I'll reach back out to them.
Thank you. All right, well, let's get on the record. We are back in 20 SC 176922, State versus Pritchett and Robinson. It is Thursday, May 2, a little after 2 in the afternoon, and we are here for sentencing. Several days ago, the jury came back with a verdict of guilty on most counts, not guilty on some counts as to both Mr. Pritchett and Mr. Robinson. We have in court Mr. Hiles for the state, Ms. Mignot and Ms. Blake are here for Mr. Robinson, and Mr. Pritchett is here for himself. And I'm going to start with the state, as I should, and then we'll work our way around, and I'll hear from Ms. Mignot and Mr. Robinson, if there's anything he wants to say on his behalf, and then we'll get to Mr. Pritchett. Mr. Hiles, you can structure your presentation in any way you want, and you should let me know if there are any of the victims who are going to be plugging in, or if you'll be saying anything on their behalf when you get to that. What I'd like you to do first, and then take it where you want, is share with everyone what merger, if any, you think happens with these different counts, so we know what's our universe of guilties that we're working through for purposes of sentencing.
Yes. So the mergers for the individuals that were convicted, for the victims, the counts were based off of armed robbery and ag assault, for which the victims or the jury found the defendants guilty on both of those counts, applying to each one. The ag assaults will merge.
So just as an example, count 9, which would be the aggravated assault of Mr. Carmody, would merge into count 2, yes, which is the armed robbery. I think he said Carmody, Mr. Carmody.
Yes, and then count, as in, yes, so count 9 merges with count 2.
I can figure that out, but you don't need to. I'll manage that part. But you agree, I agree. I'll hear from the other side in a minute, that the aggravated assaults would merge into the armed robberies of those situations where a defendant was found guilty of both. There are a few. All the ag assaults were guilties, but there were some armed robberies that weren't. There's no merger into a not guilty. So just taking Hooper as an example, that aggravated assault guilty, which would be count 15, is a 1 to 20. There's no sentence for count 3. Whoops, that's a bad example. Walker, count 4, not guilty armed robbery, but guilty ag assault, count 10. There's no merger to occur.
Correct.
Okay. Any other merger?
I don't believe there are.
Okay. Ms. Mignot, do you agree with Mr. Hiles's merger analysis?
I agree, Your Honor, that any ag assault that is also a conviction for the armed robbery would actually merge, and any that are not would not.
Okay. Mr. Pritchett, you and I haven't talked about merger much, but it's not procedurally proper for a defendant to be sentenced for 2 offenses that actually relate to the same overall conduct. The way the state charged the armed robberies, within the armed robbery was an aggravated assault. So if you were found guilty of both, the armed robbery, if you will, sort of consumes the aggravated assault, and it wouldn't be appropriate to sentence you on both those. If I did, it would just get sent back and say, don't give Mr. Pritchett a sentence for the aggravated assault. Do you have any disagreement with the analysis you've heard from the 2 lawyers? Okay. That's how I'll structure it. Mr. Hiles, your time.
Yes. So is that all right if I sit so I can speak into the microphone?
Yes.
Okay. So one thing before I get started on recommendations, there was a motion notwithstanding, or a motion for judgment notwithstanding the verdict that was filed.
Yes.
Alleging the state of prosecutorial misconduct as it applies to some of the slides that were in the state's closing PowerPoint.
So before you go any deeper into that, I'll be entering an order soon. There is no such thing as a motion JNOV in criminal cases. Procedurally, it doesn't exist. So I'll be filing an order that just dismisses it. It's all fodder, I think, appropriately for a motion for new trial. But I just didn't have time today to get to the order dismissing the motion JNOV, and it has nothing to do with the substance of it. So you don't need to push back on the substance of it. That might land in a motion for new trial, and then one of your colleagues can make whatever record he or she wants to make. But I don't want us to get into any of the substance of it because I'm dismissing the motion.
Okay.
Okay.
As it is, those slides are not part of the record.
Okay, but
Okay.
Now you're getting into something that I just said I'm going to dismiss. So why don't we talk
Would
about
you like
sentencing?
me to do, now, would you like me to go through both Mr. Robinson and Mr. Pritchett and then allow them to go separate, or do you want to do each one individually?
I'd like you to share everything and anything about the two sentencings, and then I'll turn to Ms. Mignot, and she'll share with me what she wants and anyone who's here on Mr. Robinson's behalf, and then we'll do Mr. Pritchett. So you'll do both.
Okay. I'll start with Mr. Robinson since he's closest to me. In recommending his sentence recommendation, I'm going to cite to OCGA 1511-703, which is part of the juvenile code, which states that it is proper and the court should consider adjudications of delinquency in criminal cases for sentencing purposes. There are a few allowances as to when the court can use adjudications of delinquency, one of those being sentencing for criminal offenses. And that's OCGA 1511-703. He has quite a lengthy juvenile history.
How old was Mr. Robinson when the November 8th, 2019 conduct occurred?
November 8th, 2019, I believe he was 20 years old.
Okay. So he had a window of adulthood in which he got 0 convictions, but you're going to share with me some juvenile delinquency findings.
I am. Okay. So in 13 DL 05889, he was adjudicated delinquent for entering auto, possession of tools for commission of a crime. In 15 DL 02085, he was adjudicated delinquent for aggravated assault. In 15 DL 03492, he was adjudicated delinquent for false imprisonment and possession of a pistol by a minor and criminal damage to property in the 2nd degree. In 15 DL 05021, Mr. Robinson was adjudicated delinquent for robbery. In 15 DL 03542, Mr. Robinson was adjudicated delinquent for entering auto. In 16 DL 02599, Mr. Robinson was adjudicated delinquent for criminal trespass and disorderly conduct. And in 16 DL 03803, Mr. Robinson was adjudicated delinquent for aggravated battery and robbery. Your Honor, the aggregate sentence, and I'll go count by count, but the aggregate sentence that I'm asking for sentencing in Mr. Robinson's case is 35 years to serve, with the last 5 years being suspended on the possession of a firearm during the commission of a felony.
So not 40 to serve 35, it's really 35 to serve 30 with 5 suspended.
Yes.
Okay.
I'm asking on count 1, home invasion, 20 years to serve.
And share with me what you think the sentencing range is. You don't need to share with every armed robbery, but what do you think the sentencing range is for home invasion?
Home invasion is 10 to 20 years or life.
It's just like armed robbery.
Yes.
Okay.
Armed robbery is 10 to 20 years or life. Aggravated assault is 1 to 20. Aggravated battery is 1 to 20. Violation of Street Gang Terrorism and Prevention Act is 5 to 20. And possession of a firearm during the commission of a felony is 5 years consecutive.
Okay, thank you.
As to count 1, the state is requesting a sentence of 20 years to serve in custody. As to count 2, the state is armed robbery, Holden Carmody. The state is asking for 20 years to serve concurrent to count 1. As to count 3, armed robbery, the state is asking for 10 years to serve consecutive to count 2. As to count 6, armed robbery, Jackson Buckingham, The state is asking for 20 years to serve concurrent with count 1. As to count 7, the state is asking for 20 years to serve concurrent with count 1. Count 9, I believe, merges with count 2. As to count 10, the state is asking for 20 years to serve concurrent with count 1. Count 11, the state is asking for 20 years to serve concurrent with count 1. Count 12, I believe, merges with count 6. Count 13, I believe, merges with count 7. Count 14, the state is asking for 20 years to serve concurrent with count 1. Count 15, I believe, merges with count 3. Count 16, the state is asking for 20 years to serve concurrent with count 1. Count 18, the state is asking for 20 years to serve concurrent with count 1. As for count 19, possession of a firearm during the commission of a felony, the state is asking for 5 years to serve suspended, which would be run consecutive to count number 3. Your Honor, the basis for this sentence is, I do understand that the nature of the juvenile offenses, that he was a juvenile at the time. However, there are several that are incredibly violent that he was adjudicated delinquent for. And though there might have been 3 years in between his last adjudication of delinquency and the commission of this crime was incredibly violent. It was not just a go into the house, show a gun, and give me your possessions. 2 people.
Which in and of itself is bad enough. You say it's not just go into a house and show a gun. I mean, that already is really serious and bad and dangerous.
No, I am. It's terrible.
Yeah.
It is absolutely terrible. But the injuries sustained to Vic Gattani were terrible. He had a fractured skull, severe lacerations. There was months that he spent where he wasn't sure if he was going to be able to drive again or walk without a cane because of the vertigo that he was experiencing. And not to mention, all of the victims testified as to the traumatic effect that this had on them, not only having the guns in their face, but watching their friend be mercilessly beat as he was begging for mercy and seemingly complying with all aspects of this particular crime. I think that the 30-year sentence on those charges is fair and appropriate, given the age of the defendant in the violent nature of the charges, the traumatic experience left on the victims who all testified to the PTSD involved, as well as in combination with the pattern of violence even in his juvenile years. So that is what the state is asking for as it pertains to defendant Tyrone Robinson. Now, moving on to defendant Max Pritchett, the state is asking for a total sentence of 45 years to serve, all of that service being incarcerated. And the state is requesting the breakdown in this nature. Count 1, home invasion in the first degree, the state is requesting 20 years to serve. Count 2, armed robbery of Carmody, the state is requesting 20 years to serve concurrent with count 1. Count 3, armed robbery victim Hooper, the state is asking for 20 years to serve consecutive to count 2. Count 6, armed robbery of Buckingham, the state is asking for 20 years to serve concurrent to count 1. Count 7, the state is asking for 20 years to serve concurrent to count, concurrent to count 1. Count 9, again, merges with count 2. Count 10, the state is asking for 20 years to serve concurrent with count 1. Count 11, the state is asking for 20 years to serve concurrent with count 1. Count 12, I believe, merges with count 6. Count 13, I believe, merges with count 7. Count 14, the state is asking for 20 years to serve concurrent with count 1. I believe count 15 will merge with count 3. As to count 16, the state is asking for 20 years to serve concurrent with count 1. Count 18, the state is asking for 20 years to serve concurrent with count 1. Count 19, possession of a firearm during the commission of a felony. The state is asking for 5 years to serve consecutive to count 3. And as to count 20, possession of a firearm by a first offender probationer, the state is asking for 5 years to serve concurrent with count 1. Your Honor, the same aggravating circumstances of the violent nature of this home invasion that I just described, as in recommending the sentence to Tyron Robinson. I will just reiterate those instead of going into them again, but I feel like they apply equal in nature, if not more, to Mr. Pritchett. Additionally, Mr. Pritchett was given a chance, and it wasn't brought up in front of the jury, but he was given a chance after it was a burglary, but it was a home invasion style burglary. There was no weapon used, but the door was kicked in to a man who was at home and in fear for his life.
Is that why this may have occurred before your time, but that was charged as a burglary plus felony murder because there was no deadly weapon in the mix? I mean, they couldn't have used anything on Mr. Greer because he had already jumped to his death. But the cooperators didn't say we all had sledgehammers or knives or guns?
Yes, because the death occurred during the burglary. It was a simultaneous thing, and he was trying to climb and or jump. It's unknown, but that happened as the defendants in that case had breached the door.
I didn't ask the question well. I understand the felony murder piece. I'm curious why it was charged as burglary and not home invasion. Was it because there was no evidence that they had deadly weapons on them?
That is correct. There was no evidence of deadly weapons. There was none from the surveillance, but yes, that's why it was charged as burglary. Correct. But nonetheless, he was part of the planning. He got all of the discovery. There are part of the record in this case, as to even the Ferretta hearings, there have been jail calls entered where into the record of this case as to Mr. Pritchett acknowledging the receipt of my 418 motion, stating that it's based off of the discovery that they had already received and gone through in the death of Jose Greer. That is a huge, huge break to be getting a second chance. He was given a second chance. And I was debating whether or not to ask for life in this case, which maybe he would have been eligible at some point for parole, but that would have been no guarantee. But I do think the 45 years to serve, considering the fact that he was charged with murder beforehand and not 9 months after being released from custody on that case, is involved in an incredibly violent home invasion. Not to mention convicted of doing so in furtherance of the Young Slime Life gang, which I guess would also apply to my sentence recommendation for Robinson as well. But those are that is the reasoning of the state and the recommendations of the state, and I would just ask that the court follow the state's recommendations.
Two things. One, from your review of Mr. Robinson's juvenile history, were there any gang-related aspects to any of those delinquency findings? Or that's just, you can't tell from looking at the dispositions?
I cannot tell if there was any gang-related And the only thing I do know is I did not see any gang allegations in those records, but I cannot say as to the facts of each case.
Have you seen that before, that in juvenile court, they'll tack on a street gang terrorism and prevention act allegation to a juvenile?
I have seen that, and there's a massive push and pull between the state and juvenile judges as to whether that it's a point of contention.
Sure. What does it mean to be a knowing and active member when you're 13? You even understand what it is you're doing. Not that he was 13 at the time, but I can understand why there would be a policy debate between the judges and the prosecutors. Okay. My other question was, is there any victim impact, anything from anyone beyond what we heard at trial?
There's nothing. No, only that each one of them reiterates that they are.
We would object if the victims, it's my understanding, if the victims did not appear, the court cannot hear victim impact statement from the state.
Okay. I have a different understanding, so you can keep going.
So no, just reiterating the traumatic experience that several of them, even if they weren't physically injured, spent years getting over it, if not still dealing with the traumatic experience. It was a lot just for them, some of them, to testify. And they wanted me to reiterate that they even pushed back on me against testifying because they didn't want to relive the experience. Outside of that, it is.
Or get cross-examined about the lines of work they were in, but I understand that.
Yes.
It was not easy for anyone.
Drugs.
Okay. I very much appreciate your presentation, and I can understand why some of them aren't here. They don't live in Atlanta, and others are. They're relieved to have maybe closed the book on this. Okay.
And they'll never
Thank
come
you.
back to that state.
Let me see before I pivot to Ms. Mignot, if we do. Ms. Roberts, good afternoon. I have two questions for you. Criminal history information, if any, on Robinson, that's number one, and Pritchett, that's number two.
Good afternoon.
Hey there.
Robinson does not have any felony convictions listed on his GCRC, and I'm showing 2 cycles. And Pritchett, I am showing a total of 4 cycles, 2 out of Georgia, 1 out of Texas, and 1 out of New York. Also, I do not see any felony convictions listed for Pritchett.
Pre-trial.
What was the Texas cycle?
2017 for possession of marijuana less than 2 ounces and possession of a controlled substance, Schedule 2. Looks like that case was dismissed December 21st, 2018.
Okay, and the New York, I think I know, but what does it say in the NCIC?
April of 2016, officer fails to bring person arrested on extradition warrant to court. The disposition was not arraigned.
Okay. Thank you so much.
You're welcome.
Ms. Mignot.
And Your Honor, is there a preference by the court if I have a family member speak on behalf of Mr. Robinson prior to getting into the law and asking the court for its sentence?
Any order you want to do it. This is your presentation, so I will respect your approach.
Thank you, Your Honor.
Sure.
At this time, we call Ms. Robinson.
Okay.
May we have her stand here?
Yeah, ma'am, if you don't mind coming up to the podium, that way the court reporter will be able to hear you.
Good afternoon, Your Honor.
Good afternoon. And if you could state your name for the record so the court reporter knows whose word she's taken down.
Catherine Robinson.
Can you spell your first name?
Catherine.
Okay. When you're ready.
I would just thank you for the opportunity for me to speak on behalf of my son.
Sure.
I would like to start off as Tyrone was born 9/10/1999. When Tyrone was placed in daycare, I used to get these phone calls saying, Tyrone hiding up under the toilets. And I was like, what's wrong with him? I have to take out work, go see what's going on with Tyrone. So I decided to take Tyrone down to Hugh Spalding and have him checked out. And they say, Tyrone, okay. I take him back to school. Something going on with Tyrone again. I take him back down there. to Hughes Spalding again. Tyrone, okay. As he got older, it kept going on and on and on.
The going on isn't that he's getting in trouble, it's that he's kind of hiding somewhere?
His mental.
Okay.
So as he got older, it was going on and on and on. So they say the state is the help. I called defects on myself, trying to get myself some help. Defects came out to my home. They said, I have food in my home, no bruises on my kids, open, closed case. As he was going to school, middle school, Tyrone he's doing his work, but he keeps shutting down on this, crying out for no reason. He won't tell us why he crying. I go to school, take out work, go up to the school. Tyrone, why you crying? What's wrong? I don't know, mama. Something in my mind just telling me to cry. I'd be like, baby, stop crying. It's okay. Take him home with me. Tyrone, why you crying? I have had Tyrone in numerous mental health facilities. I have had him put in youth village, this mediologist home. I mean, Tyrone been placed in numerous mental facilities. He been on numerous medication.
What do the doctors there tell you? You're now going to folks who can die. It's not Hugh Spalding saying, right, bruises, he's okay, or DFAC saying, you're a great mom, household is safe. You've now got mental health professionals spending time with your son. What do they tell you their concern or diagnosis is?
Depression, ADHD. It's been so many of them. I have them listed.
Did he get medication for those?
Yes. He was on a lot of medication. So, like I said, Tyrone always been a smart kid. The charges that Mr. Hall is bringing up on the armed robbery charges, he was with another kid that committed those crimes. Tyrone was never convicted of those crimes. And the guy came to court and forgave Tyrone for those charges. That was the only way to get the proper help for Tyrone. He helped me get Tyrone into this program where the state, he was in the state custody, but he was in state custody, but still in my home. So they'll come out to the home, make sure Tyrone took his meds. I proved to them that he took his meds, and I did make sure Tyrone stood at the bus stop and got his GED. So he do have his GED, but Tyrone is a good kid. I have 3 kids. I have a 27-year-old. She just got done with college. I have a 16-year-old. She's a junior in high school. She plays soccer. She's in JROTC.
Where does she go to high school?
South Atlanta High.
Great.
Tyrone is a good kid. He have a lot of mental issues that never been addressed the proper way.
When your son was taking the medication that the doctors prescribed, did that seem to you to help? That he would be, he'd get upset less often?
Some of them helped and some of them didn't help. Some of them used to make him too drowsy to where he can't do anything. Some of them made him think a little negative, but he didn't do negative. He used to hide himself up under the sofa, behind the toilets, but he's never did anything negative. So as a parent, Your Honor, like I said, the state have failed me terribly. I called defects on myself twice for help with Tyrone. So as a mother, Your Honor, I'm just asking you, before you sentence my son, I'm begging you to give him a second chance. Let's help Tyrone and get Tyrone in the right programs that's gonna help him before we destroy his life.
Okay. I appreciate you sharing that. There's always much more context to every individual than
I have several records of Tyrone being in different facilities of just me trying to help him. The state never tried to help me. I always beg the state for help. They come into your home and say, you got food in your house, kids got clothes, they got beds, no bruises, open, closed case.
Okay. Well, I want to be clear. It sounds like you took all the steps you could to provide for your son.
Mhm.
There were clearly times when he was far outside your supervision, and he reached the age where it was okay for him to be outside your supervision. And whether it's due in part to some of the mental health issues he was struggling with.
He had a lot of mental health issues. He was diagnosed with ADHD, depression. He was on borderline with autism. Tyrone suffered with a lot of mental health issues. He have tried to commit suicide on numerous occasions, which I have got phone calls saying that he tried to commit suicide while he's been incarcerated. I just ask that we help Tyrone before we mess up Tyrone's life.
Okay. I appreciate you sharing that. Thank you. And I appreciate you being here throughout the trial. He had someone for him, and we don't always see that. And that's even more depressing when there's a young defendant. He's got his lawyer, but there isn't family there for him. So thank you for that.
Thank you, Young.
All right. Ms. Mignot.
Thank you, Your Honor. May it please the court, on behalf of my client and his entire family, I have to say that it is an honor to do my duties as an advocate on behalf of sometimes people who are the forgotten, the lost. And unfortunately, it's not until we get in a situation like this that people like me have an opportunity to try to address the honorable court on behalf of what I think is going to benefit not just my client, but society as a whole. If we are honest with ourselves, we know that people like Ms. Robinson and her son exist. And no matter the efforts that they make to try to get the needs of the child addressed, that unfortunately sometimes delay is denial. And the child gets to an age where the parent is being told by authorities, unless you have some type of court order stating that you can speak on behalf of this individual, we're not going to hear anything from you. So as it pertains to my client, Your Honor, at the time of this incident, he was 19 years of age. And unfortunately for him, I was approximately lawyer number 3 or 4.
At least 3.
At least 3, Judge, on the roster. And by the time we got involved in this case, a lot of time had passed. And there was a lot that we could not lawfully do to catch up or fix because certain deadlines have been passed. So I submit to the court that my interactions with Mr. Robinson, he does need help. And the first thing I'm going to ask the court for in this situation, although it may seem like I shouldn't be asking for it, will be some type of probated sentence that's going to help him to be evaluated and treated. Because I think if we get him evaluated and treated, we can stop what our system wants to stop, and that's recidivism. This court, I am preaching to the choir, is involved in drug court, is involved in mental health court, is involved in rehabilitative efforts in this county to try to make sure that individuals such as my client get an opportunity to treat what the underlying issue is and be able to become a productive citizen in society. I submit to this court my interactions with this young man, he can get the help. And if he gets the help, he's going to become a productive citizen. He has never been anything but respectful in his interactions with me. He has never been anything but polite in his interactions with me. And his story breaks my heart, not just as an attorney, but as a mother, because I know that if Tyrone Robinson had gotten the assistance he needed as it pertains to the signs and the underlying medical issues he had, that we probably wouldn't even be having this conversation. Your Honor, his record is extensive, and unfortunately, I could not file some of the things that I would have filed had I gotten in this case earlier. But there's mention of autism spectrum in the records. There's mention of bipolar disorder. There's mention of schizophrenia. There's mention of a lot of mental health, and his history goes way back to youthful, prior to his juvenile cases that the state want to allege. And I submit to the court that even though he has those scrapes with the system, no one made sure that there was follow-up associated with it. As it pertains to the one that the state mentioned that the state believes is a aggravated assault offense, my client was sexually assaulted in that situation, and no one protected him from the sexual assault. And that case requires him to defend himself. So the facts, if the court is to look behind the veil of just a charge and get to the facts of what was going on as it pertains to that situation, the adult in that situation would have been dealt with prior to my client having to deal with the adult themselves. I get to the sentencing in this case, and I submit to the court that as it pertains to what happened to these victims, and I don't want to discount that, what happened to these victims, Your Honor, is real. It is real, it is traumatic, and I don't want to discount that. But I'm asking this court to look at the totality of the circumstances surrounding this case, including but not limited to some of the evidence that was surprising to me, that some of the alleged victims took a flight and went straight to a Travis Scott rap concert the morning of the same incident that the state is professing was so traumatic for them that they can't talk about it. I know everybody is traumatized by court, so I'm not discounting the fact that having to come here and testify and all those things are not traumatic for alleged victims in this case. Mr. Gattani, I am sympathetic. A scar is going to stay with him, according to the allegations in this case, for the rest of his life. I totally understand that, Your Honor. But as it pertains to the evidence in this case, which the court heard, I submit to this court that I still believe that there are some issues associated with the evidence in this case. But we are not here for that today. Right. We are here for sentencing. So as it pertains to the counts that have not merged, I have come up with what I believe is the resolution that the court would be able to address all the issues at the same time. As it pertains to the home invasion, Your Honor, we would be asking this court, because the sentence minimum is 10 to 20, to sentence Mr. Robinson to the minimum sentence of 10 to serve 5, credit for time served, because he has been in custody since his arrest. His bond, I believe, is at $1 million. He couldn't make it, even if he tried. And he has served. He's going to be here. I believe he got into custody. It was December, if not the 6th, the 9th of 2019. And he has been in custody since then. So we'd be asking the court to give him credit for time served on the home invasion. As it pertains, Your Honor, to any of the counts that did not merge on the possession of a firearm, that sentence be a 5-year probated sentence, because that probated sentence is going to give the court the power to order the evaluation, mental health evaluations and treatments and follow-ups that Mr. Robinson is going to need, assistance with employment, housing, all those things that he is going to need help with. And that is the sentence that I am most important with, because it's a consecutive too. The statute requires it to be a consecutive sentence. As it pertains to the aggravated battery counts, we're asking the court to sentence Mr. Robinson to 5 years credit for time served and run all of them concurrent. As it pertains to the aggravated assault, we're asking the court to sentence him to 5 years time served for the time that he's been in the custody. And once again, Your Honor, as it pertains to any of the other sentences, as it pertains to the armed robbery, I'm sorry, those are the only counts that I have not addressed as yet. The armed robbery counts, we're asking the court to sentence to the minimum of 10 years. And pursuant to Jackson v. State, which is 338 Georgia App 509, this court has the ability and the legal ability to consider deviation. And we would ask the court to consider deviation as it pertains to that sentence, and to sentence Mr. Robinson to a time served on those counts.
She's asking also to go lower than the minimum.
Your Honor, the most important thing for us as it pertains to this court sentence is the mental health evaluation, treatment, and assistance that Mr. Robinson did not get the first time he interacted with the judicial system. We thank you, Your Honor, for your grace and your mercy as you pronounce sentence upon our client associated with this case.
I have a question for you that predates your involvement by many years. But I'm curious if in working with your client, his mother, you got a sense as to how or why Mr. Robinson wasn't connected with mental health resources through juvenile court. I understand the DFAC story and going to Hugh Spalding, but what I understand and have experienced with juvenile court is that they're very focused on the needs of the child. And it would surprise me to learn that in no instance were there steps taken to connect Mr. Robinson with the appropriate resources. I know that predates you, and I'm not wanting to hear anything privileged. Right. But that little piece is missing for me, is how he clearly was well known down at juvenile court, and a track record like this is exactly the kind of track record that would prompt the judges and the entire social services support network there to say, what can we figure out to try to bend this curve in a different direction?
I did look into the records, Judge, and it was mind-boggling to me because I couldn't connect any dots to, and you are hereby ordered to the services of. Yeah. So he might have just been one of the many cases that they were dealing with at the time that just slipped through the cracks. And unfortunately, time moves faster than we anticipate. So once you hit that 17, 18 mark, nobody's looking at you anymore and juvenile cases are closed. Goodbye, good luck. Yeah. I did try to look into that, Judge, and I can assure you that the records that I looked at, which were extensive, didn't include any follow-up. And that's why today it was most important for me to focus on him getting assistance. My concern is that state prison is not going to get him any assistance. And unfortunately, because of how the state prisons are run across this country, that what you do is go to state prison to learn how to be a better criminal. So when you come out, you are guaranteed recidivism. They might as well give you a diploma in crime, because that's pretty much what you're going to learn. Because we're not focused on rehabilitation, we're focused on incarceration. So you sit there, and then we let you out on society and hope that somehow psychologically something clicked on and the light bulb went on. And if I had cancer, Judge, and you lock me up, it's not going to cure my cancer. So I am begging this court to do something which I know this court has the ability to do and is willing to do based on your history, your resume, and what I've looked at that you've done. He couldn't ask for a better judge to be before, as it pertains to making sure he gets the help he needs so that he can become a productive citizen. All right. So thank you again, Judge.
You bet.
For
thank
allowing
you.
us to address the court.
Yes, ma'am.
When Tyrone was committed to the
Can you come up? The court reporter needs to be able to hear you. Thanks.
When Tyrone was committed to the state, was still in my custody at the age of 19, I still didn't get no help. The only thing his probation officer did was make sure she came out to my home to make sure he was in the house. Anything else was on me. Making sure he get to counseling or get the proper help, medication, everything was on me. They was only doing paperwork. Everything was still on me. The state didn't help me. The state failed me as a mom with Tyrone.
All right. I'm sorry to hear that, but thank you for adding that.
Mm-hmm.
Oh, I didn't know that his sister would arrive, Your Honor, but she is present. If you'll just stand up in support of Mr. Robinson, his sister has arrived, Your Honor.
Thank you for being here.
This is the first time I've seen Mr. Robinson turn around.
Mr. Pritchett, it is your, before we get there, Mr. Robinson, you have a right to, we call it allocute. Say anything you want. You don't have to say anything at all. It's sort of like whether you choose to testify. And you've had a very eloquent speaker too on your behalf, your mother and your lawyer. But I'd be making a mistake if I didn't give you the opportunity to say anything you want or nothing at all. But I need you to say on the record, I don't have anything to say, or whatever it is you want me to know.
I don't have anything to say, Your Honor.
Okay, thank you. Mr. Pritchett, you are up, and I'm going to need you to come up to the podium because you don't have a microphone at your table. Thank you. Good Good afternoon, sir. What do you want me to know? And do you have anyone who you have to speak on your behalf?
I believe one of my family members that are here today, my father.
Okay.
He would like to speak on my behalf.
Do you want that to happen first, or are there things you want to say first? You control the order in which we do these things.
That can happen first.
Okay. Sir, if you'd come on up. And Mr. Pritchett, if you just sort of slide over there. Thank you. Good afternoon, sir.
Good afternoon, Your Honor.
Could you please state your name for the
Pastor Dominion, and without further ado, I want to thank you for this moment and opportunity.
I need your name for the record.
Oh, yes. Prentice Dominion.
All right. Pastor Dominion.
Yes, sir.
When he said father, I think he meant church priest.
Okay. I want to ultimately, bottom line, I want to just share a little history in Atlanta that I have personally, number one, saw with this landscape. Number one, I've served with two of the administrations here, from Kasim Reed and also with Ms. Bottoms, in regarding to my ministry, which is totally humble under God, which is, Your Honor, thug ministry, totally humble under God. And what we saw in these last few years, as you see in the other court and this court, if you look at the landscape, you'll be able to see, number one, in this case here, we saw, I'm not going to say youth or young adults, all ethnicities. And what we saw was drugs, robbery, music. What I've seen so much and what I've been able to assist with, I've seen a lot of these things, of course, bottom line, stimulate from this music that we have right now. Of course, my son, of course, I've sent him off to Morehouse. Very astute, a great student. One thing I've experienced in this lifetime that I see right now that's happening, we deal with an issue, but of course, there's an underlining. And the underlining, there's also a spiritual component that has to be dealt with. The Bible tells us, of course, to guard our heart with all diligence. And one of the things I noticed that we are seeing right now here in Atlanta and across these states is that we are seeing, number one, the music being a great culprit that's allowing virus in these kids' hearts, and we're seeing kids being affected. One thing I do know, there needs to be a change because we are being challenged as the courts, those who in law enforcement, we're seeing a challenge that right now that's getting completely out of hand. I studied a child who for 3 hours a day, 5 days a week, listening to rap music. Number one, we see their hard drive infected. If you're listening to, I smoke weed, I do drugs, I do this, 3 hours a day, 5 hours a week. The real culprit that I see is not here on trial today. That's the Sonys and the EMI and the Arista Records that are paying these guys $1 million to $2 million just to be exploited. And we found ourselves landed here because we have kids who are not guarding their hearts, but are listening to this music. And ultimately, we see them now with virus on their hard drive. And you and I both know when your hard drive has a virus, what happens? We click and it takes us somewhere else. I send my kid to Morehouse, clicks, it takes him somewhere else. But of course, one of the things that I experienced also, he had a love for music and I thought he was going to be successful in music. And I see this challenge right now. I've had the opportunity to experience, I'm going to say, a nightmare. On the streets of Atlanta, another child who was in music. In 2017, Your Honor, he lost his life. Supposedly to the world, a great rapper, but again, he lost his life in the streets. So what I've seen also as well, I've seen my son Max also be greatly affected by this, the family affected by this. I believe ultimately if we're going to turn this around, it has to be a spiritual component, a spiritual answer as well to the plight of these youth who are coming before you every day. As we've seen with the landscape here, what are we going to do about the individuals that left here and that we would know they're involved with drugs or into rap music? And then, of course, we have another group here charged with a crime of a home invasion. Neither one of them works for the community. Neither one of those situations are something that we want to actually, bottom line, feel that's going to be great for the community. How do we change this? I believe it has to be a component to where we all come in an agreement that we must invite the Lord in this. Now, my son, I want to say, I know this is a terrible situation. But him himself personally, I'm going to say is a great kid, knowledgeable. I brought him up in the Lord. This is kind of hard for me right now. There's a level of trembling right now because I know the effects are grand. But I know we know we serve a great God. But even right now, I've heard all the numbers. I've heard the state's suggestion. I asked the court that we put in consideration the complete landscape. What is the complete landscape? Max comes from a family who serves the Lord, serves the community. I'm going to say grew up in the Lord, grew up at the altar. What I do want to say is he's had a tremendous amount of experiences in his life in these last 15 years. Tremendous. What do we do as a parent? What do we do as a parent? We pray and we believe and we trust God that we will never end up in these situations like this. What am I asking the court? The same thing I'm asking the Lord. Justice, of course, but I'm asking for mercy. I believe right now, without a shadow of doubt, with a chance, by faith, not only can he be a productive, law-abiding citizen, I believe he'll have an opportunity to become who God has ordained him to be, a man of God. With all that being said, I do know, Your Honor, this is not something that, again, you do hope that we're going to be able to rid this problem that we're seeing happening on the streets right now. The guns and the murder and the music and et cetera. But how do we bring that change? How do we bring that change? I believe that change comes your job, and I believe there's a spiritual component, me continually preaching the gospel and the good news of Jesus Christ, that ultimately is going to change someone's heart. And I believe that right now is a great opportunity right now for the mercy of God, even right now, as I share my son's plight. And I believe overall, it's kind of tough, but I do want to say, I believe overall, you're going to see a changed citizen with another chance. I do believe. So I ask by the power of God that you just, as you make a decision, I hope and pray that the court would have mercy. And even right now, I pray that you even give Max an opportunity to move forward. In Jesus' name, amen. Amen.
Thank you, Pastor Dominion. And thank you for the work that you do outside this courtroom. Mr. Pritchett, if you'd come back up, please.
I think his sister wanted to speak, Judge.
Oh, okay. Good afternoon, ma'am.
Good afternoon.
Could I have your name, please?
Sarah Pritchett.
First name is spelled?
S-A-R-A-H.
All right, Ms. Pritchett.
Good afternoon. As you know, I've been at every court date with my brother, Max Pritchett.
At least every court date.
Yes, I've been by his side, and it has been a long journey, and I know that some difficult decisions have to be made. And ultimately, I just want to let you know who he is to me. Max Pritchett is my brother. we grew up in the house where it's just us. We're very close knit, come from a great family. We're like 2 years apart, and we grew up in the church. We have always got along. It has never been any, as far as he has never had any trouble growing up or in his like past life to where things have been crazy. Me and my brother have suffered through a tragedy when we lost our older brother. And I'm really asking if you can have mercy on my brother, because I already lost one brother to gun violence, and I don't want to lose another brother to the system. And with the faith that I have in God, I know that he will never be lost because it's always hope. So I'm just basically asking if you can have mercy with him, because Max is a great person. He has always been, he has taught me so much in life. I'm who I am today because of my brother. He's my hero. He's my best friend. And Max, he's not a gangbanger. He's not in a gang. He has never been. And I really want to make that record known. Max is not a thug. He's never been a member of a gang at all. Never has been. And as long as I've known Max, he's a good kid. He's smart. He's great in basketball. Grew up academically smart, and he's just a great person overall. And I just want the court to consider in what you give him, because I know that the prison system is not ordained to grow a person mentally, spiritually, and I've seen nothing good come from that. So with another chance, I will believe that he will be the God-ordained person that God wants him to be, and still be able to live a life according to the law, of course, and the word of God. So I'm just basically asking you to just consider just a different take on what the state is trying to give them. Thank you.
You're welcome.
Guys, let's be respectful of people's beliefs. I think they are heartfelt beliefs. I have my own beliefs. I think what this shows is there are victims to crime that are on both sides.
How do we go about
this? Family.
You say whatever you want to say. This is your chance. It's a little different from Mr. Robinson because you're your own advocate. And so you don't have to say anything at all. This is your time to allocute, to say, here's what I think you should do, and here's why. But you're not under any obligation to say anything. I've now heard from your father and your sister, providing an important other view into your life, because obviously what I heard during the trial isn't your best side. But your father and your sister have helped me understand what I knew to be the case, that everyone is multifaceted, and it is rare for someone's sister to come in and say, I hate my brother, you should lock him up for 1,000 years, unless she was the victim of the crime. And that's not her role in this. If there are things you want to share, now is the time, but you don't have to do anything.
One scripture that comes to mind is in James, and it's that mercy triumphs over judgment. And I believe, God, according to his word, desires repentance over punishment. And I believe in this day and age, 2024, we do have to look at reality for what it is. And the prison system doesn't save. But I do believe that every life is worth saving, including mine. But again, everybody's life is worth saving. And I say that to say that state's recommendation of that time is not saving my life. but it is more, it is definitely more destroying it. And I just firmly believe that even over the course of these 4.5, 5 years that I have already been incarcerated, it wasn't the bad conditions that I'm surrounded by. It wasn't the stabbing and the suicidal that I'm surrounded by. It was none of these things that caused me to look, at myself and create a deeper change within me. It was none of those things that caused me to do that. It was, I believe it was me crying out and searching for God himself that really caused me to do it. I'm not sure exactly why. It took this for me to really search and cry out for God in a genuine, full-hearted, wholehearted way. But I know sometimes it does take those drastic measures for a person to really, build that relationship with God and their Creator, which I believe is everyone's duty on this earth, and everyone's duty is also to fear God and follow His commandments. And again, I believe that, like I said, over these past 5 years, I have raised my standard of just morale and value and knowledge, because the word repentance, it actually means, when you break it down, it means to gain a new understanding and to gain new knowledge. And I believe I've gained a new level of these things to really allow me to be aware, fully aware of the decisions that I make. And this is an awareness that I was lacking previously, of course, but over these past 5 years, I believe that there's been just in me a new level of change, a new level of virtue and standard of just morale again that I've reached, and going to prison for the rest of my life would put me in fear of just, degrading myself back down to a level that I never want to go back to again. I only want to get closer to God. I don't want to stray from Him. And I believe that just being in prison again for the rest of my life will put me in danger of really straying and going away from God. And so again, I am asking for the court to allow its mercy to try and triumph over its judgment. To also take into account that I do already have a 20-year sentence. And acknowledging that, I would ask the court for 20 years in concurring with the sentence I already have. But of course, in asking that, I would also just ask them to, and it may be hard, but I would also ask them to believe that within that time period, there will be a level of elevation spiritually and mentally that I will achieve, to where, again, I won't stray from the commandments. I won't stray from God. Every life is worth saving, and I believe right now with the request, I'm imposing a method that this court can possibly save my life rather than destroy it. I believe the plan imposed by the state is just destroying my life. And
state asked for 45
again,
years.
every life is worth saving. And it wasn't, like I said, it wasn't the conditions or the environment I've been in, in prison and in jail these years that it caused me to, look within myself. It was the Spirit of God Himself that caused me to do that. And I don't want to lose that. I don't want to be in a position where I lose that, ability to elevate. And so, yes, I just ask for grace and mercy. That's it.
All right. Thank you, Mr. Pritchett.
One more question. If there was a motion I wanted to file, could I do that today?
I'm going to talk about your ability to file motions and appeals and all that, both for you, excuse me, as well as Mr. Robinson. So I always prefer salvation over punishment. This is the worst part of the job of being a judge. I have excellent advocates in front of me that are pulling not in entirely different directions. No one's saying let everyone out right now and rejoice their sentence is over. But I wanted to be clear that part of what necessarily flows from a jury finding defendants guilty of multiple armed robberies and aggravated assaults where people were left praying for their lives, seeing their lives flash before them, not sure whether they'd live to see the next day, are pretty meaningful consequences. This case is very different from a shoplifting or an entering auto. There are 7 people who will never forget what happened to them, and what happened to them was in no way a good thing. And that is what drives this, not some refusal on my part or the system's part to appreciate that the lives of those who were accused and convicted in this case were complicated leading up to these events. Mr. Robinson, I'm going to start with you. I appreciate from hearing from your mother and from Ms. Mignot that many of the early years of your life, you were underserved by the community. You had needs that were not met, and they weren't unrealistic needs. They were important needs. But I also got to see a side of you that was smart and coherent and communicative when you were interacting with people, texting, some of the videos. And by that, I don't mean had a gun in your hand or not. That's not my point at all. It was seeing you interact with people and seeing you behave in a way that tells me that while you might not necessarily have appreciated how risky some of the things you were doing were, you were very much in control of yourself and your faculties, and choosing to be a part of the actions and the activities that we saw you involved with. And so as I hear from your mother about how you've had struggles, I also see from the evidence someone who was aware of the dangerous nature of what he was going to do, but went forward with it anyway. And while I would like to connect you with the appropriate resources as soon as I can, it is, I believe, necessary and appropriate from a justice perspective that there be a period of time beyond the years you've been waiting for this disposition that is punishment for what happened. And this applies equally to you and Mr. Pritchett. You may feel very, very unlucky right now, but it was truly luck and chance that no one died that night. It was a random fact that no one in that house had a gun. Because if anyone there had a gun, legally or not, they reached for a gun. You guys have guns. Doesn't matter if your guns were real or not. Someone was going to get shot that night. And it may have been that this case was about Tyrone Robinson having been killed during a home invasion. And what do we do with the person who shot him? And the law is a confusing thing. Mr. Pritchett could have been prosecuted for felony murder for your death if you had been shot by one of the occupants of that house. And then we're talking about a dead body. That's how dangerous this situation was. And so they're just, by the grace of God, we're not dealing with dead bodies, whether it's yours or Mr. Pritchett's or any of the people in the house, should they have chosen to resist, or who knows, Mr. Gattani might not have survived getting smashed in the head. He did, and we're all grateful for that. That's just me emphasizing how serious this situation is. So your sentence, Mr. Robinson, as to count 1 is 17 years to serve. Count 2 and 3 are also 17 years to serve. 6 and 7 are 17 years to serve. The counts I skipped were not guilty, so there's no sentence there. Count 9 merges into 2, no sentence there. And all those sentences I just mentioned, the 17 years to serve, all run concurrently with each other. Counts 10 and 11 are 18 years to serve. They run consecutive to count 1. Count 12 merges into 6, 13 merges into 7, 14 is 18 years to serve, concurrent. Oh, I did the math wrong. It's eight years on all those. I apologize. So 10, 11, and 14 are 8 years to serve. They run concurrently with each other, but consecutive to count 1. Count 15 merges into count 3. Count 16 is 8 years to serve. That runs consecutive to count 1. Count 18 is 5 years to serve, concurrent with count 1. And count 19 has to be 5 years, and it has to run consecutive to count 10. And that yields a total sentence of 30 years to serve 25. And you get credit for the 5 years you've served. And your lawyer can talk to you about the years that are parolable versus non-parolable, but I structured that purposefully in that way. When you are on probation or if you are paroled, I will recommend that the Department of Community Supervision assign to you a mental health officer, and I will make it a condition of your probation that you submit to a mental health evaluation and treatment. I will also recommend to the Department of Corrections. I can't tell them what to do. I can encourage them to do certain things, but I will encourage them. They'll do this anyway, I believe. That's what I've been told, but I'm going to recommend it anyway, that they run you through the normal battery of tests to see if there's certain treatment you need and if there's a facility where you should be housed to get you the best chance of getting the treatment and care that you need while you're in custody. I'm going to talk to both of you about your appellate rights in a minute, but I want to pivot to Mr. Pritchett. Mr. Pritchett, you and your father and your sister all asked for mercy. Mercy certainly flows most readily to those who showed mercy themselves. And I'll tell you, the part that I struggle with the most is that within a few months of you being involved, and I'll agree with you, it was involved very peripherally with the first home invasion burglary in which someone died, you were back in the mix. I appreciate that you were younger, but what I have heard from your father and your sister is that unlike Mr. Robinson, you were blessed with a situation, a childhood where you weren't struggling with mental health challenges, got to college, and were afforded any number of opportunities. I wouldn't be surprised if you tested off the charts with IQ. You strike me as an exceedingly intelligent person. I watched you absorb the way the lawyers were doing what they did in court, and you fairly quickly were able to do the same. And so I'm left puzzled at how you ended up doing the things that you did, because they are very, very inconsistent with what your sister experienced. And while she called you her hero, I'm confident you're not her hero as the Jose Greer case or by being involved in this case and what you did on November 8th. But as I said, everyone is a composite of things. And I think that you've let your family down by not once, but twice getting involved with real dangerous, violent criminal activity. I'm not sure how to eliminate the virus from Mr. Pritchett's hard drive. One would think that losing his brother to gun violence might do it. One would hope that if that didn't, then the mercy that Judge Dempsey showed would have had an impact. But that was one persistent virus, because just a few months after getting out from Judge Dempsey's merciful second chance sentence, this happened. And I think I would be remiss and be underserving society if I said, well, let's have a third chance and get you right back out. You may have grown up at the altar, but you have strayed very far from it. And I'm happy for you if you have refound a spiritual way of life, and you are a charismatic person. Change starts with you, but you may be able to affect change on others while you are in custody. I hope you find that within you. Your sentence, Mr. Pritchett, as to count 1 is 20 years to serve. Counts 2 and 3 are 20 years to serve. They run concurrently with count 1. Counts 6 and 7 are 20 years to serve. They run concurrently with count 1. There's no sentence for counts 4, 5, or 8. You were found not guilty. Count 9 merges into count 2. Your sentence as to count 10 is
they separate 10 and 11 for him.
15 years to serve 10. That runs consecutive to count 1. Count 11 is 15 years to serve 10, concurrent with 10. 12 merges to 6. 13 merges to 7. Count 14 is 15 years to serve 10, concurrent with 10. 15 merges with 3. Count 16, the aggravated battery, is 15 years to serve 10. That merges, that runs concurrently with count 10.
18.
Count 17 was a directed verdict. 18 is 5 years to serve, concurrent with count 1. 20 is 5 years to serve, concurrent with count 1. And then 19 has to run consecutive to 10. It is 5 years. It is probated. That should add up to a 40 years to serve 30, partially parolable prison sentence with the balance on probation. Let me talk to you both about your appellate rights, because this would relate to any motion, Mr. Pritchett, that you're going to file. You both have the right to appeal your conviction and sentence. You can appeal it directly to the Court of Appeals. You also have the ability to file a motion for new trial. You both have the right to appellate counsel to assist you with all that. Mr. Robinson, I'm going to ask Ms. Mignot to consult with you and at your direction file either the motion for new trial or the motion for a direct appeal. And you can actually do both, but they have to happen in a certain order. The first thing that would happen would be the motion for new trial. That's something that I adjudicate. So it's a hearing in front of me about errors I made or errors your lawyer made. And so you would get a different lawyer to help you with this. And one would be appointed to represent you. If the motion for new trial is denied, then you still have that ability to appeal to the Court of Appeals, and that same appellate lawyer would help you with that. So none of this you have to do on your own, although you have a right to represent yourself. But I will ask Ms. Mignot to file within the next 30 days, one of those two things, if your direction is for her to do that, the motion for new trial, which is just a placeholder, and then another lawyer will flesh it out, or that motion for direct appeal. You have another appellate right, which is called a habeas challenge, and that right doesn't even kick in until you're done with all your appellate rights. You don't get a lawyer for that unless you can hire one, but again, that 4-year window you have in which to file a habeas challenge, that 4-year clock doesn't start until you've exhausted all your appellate rights, so it's not running right now anyway. The important thing is for you and Ms. Mignot to talk about whether you want to go ahead and go straight to the Court of Appeals or do your motion for new trial first, and then Ms. Mignot can file a one-page document that says we're doing this one or that one, and then we'll work to get you a different lawyer. You don't have to. I mean, you can talk with Ms. Mignot about it, but she will likely advise you to get a different lawyer so that lawyer can critique not only how I ran the trial, but also critique how Ms. Mignot did what she did, and thereby provide you a full scope of appellate arguments. And Mr. Pritchett, you have those very same rights to appeal. Assuming you qualify for appointed counsel, which I assume you do, meaning qualify financially, I can appoint a lawyer for you, but you're going to need to let me know that, because right now you've said I want to represent myself, and you can switch back to having a lawyer represent you, and then I will appoint someone. It won't be any of the lawyers who worked with you before. It would be an appellate lawyer trained in appellate stuff. And if you want someone appointed, then I'll make sure that happens. And then that person can consult with you about whether you want to file a motion for new trial or a direct appeal. And again, you can do both, but if you're going to do both, you start with a motion for new trial. If you win that, then that means we have to do this all over again. But if you don't win the motion for new trial, if I deny it, you still have that direct appeal right to the Court of Appeals. Let me start with you, Mr. Robinson. Do you have any questions about the appellate rights I just shared with you?
No, Jan.
Okay. Mr. Pritchett, I'll let you share with me your question about a motion, but do you understand the appellate rights I shared with you? Okay. Do you still have a question about filing a motion?
So I can't orally file a motion, 2 motions today?
So it would probably be only one motion, but you may have a different motion I haven't thought of. But the way it would have to work would be in writing. You can get something on the record if you want, but for it to be an official motion, you'd need to file it. But I will stop the clock for you if you tell me you want to have a lawyer represent you until we can get that lawyer appointed. So you won't, because you only have 30 days to file either the motion for new trial or the notice of appeal. You can file either one. And if you know which one you want to do, you can go ahead and file it. It can be handwritten, Max Pritchett. I want a motion for new trial, and that'll stop the clock and we can get you the lawyer. But I'm happy to toll the clock for you to get that lawyer if you tell me now that you do want representation. If you know you don't want representation, then there's no clock for me to stop. In the next 30 days, you just need to file that placeholder. It doesn't have to be perfected with all the grounds. It just be, this is my motion for new trial. You can't do a full-blown motion for new trial until you get a transcript of the trial. It just stops that clock, and then we wait until Ms. Rivers creates the transcript of the trial. And then whether it's you or that lawyer who's handling your appeal for you, that person goes through the transcript to see where he or she finds potential errors that I made.
I would like representation to stop that clock.
Okay.
But I just did one other motion that I was looking to file was a motion in arrest of judgment.
Okay. So you may want to talk to the lawyer about that, about how that works and whether you can do that at the same time you do a motion for new trial, or if there's a certain sequence, and what the deadline might be for a motion in arrest of judgment. And if you've got concerns about that, you could always file one yourself, because until you have a lawyer representing you, anything you file is a motion of record. As I think we've discussed before, once you've got a lawyer, it's not necessarily a motion of record if you file it, because it really should go through your lawyer, although the law has changed on that recently. But certainly right now, anything you file, that's a motion of record because you represent yourself. But what I'll do with my staff is work on getting a lawyer appointed to represent you, and I'll make sure that the 30-day clock doesn't start running until that appointment's made, so that you and that lawyer can have a conversation about which way you want to go, whether it's motion for new trial or direct appeal.
A motion in arrest of judgment.
Whether a motion in arrest of judgment is the procedurally appropriate vehicle right now. All right?
Doesn't challenge
Mr. Hiles, anything
it challenges
on behalf
the legal
of the state?
sufficiency of the trial
Did I mess
court's
the math
judgment.
up?
No.
Okay.
It's almost a opposite argument.
I think I know what they intend to do. I just asked if you put on the record whether Mr. Pritchett's sentence is to run concurrent with his 18 SC case, the death penalty.
Sure. I will repeat. I hadn't answered that. Thank you for doing that. I will repeat. I know I said it to Mr. Robinson, but it applies equally to both of you. You get credit for all the time you've been in, which is many years, towards the sentence that I've imposed, which is also many years. But Mr. Pritchett, I intend for your sentence in this case to run concurrently with, at the same time with your revocation. So it's not finish your revocation and then those other years. Those clocks will be running at the same time. And you've already booked a bunch of time as to both, but in particular, the sentence imposed here. Thank you for flagging that. I had forgotten about the revocation piece. All right, that is where we are. I appreciate everyone's time, and Mr. Pritchett will get to work on getting that lawyer appointed for you.
And we're done with that. All right, so back to back. So we're starting with BK and then with the sentencing for the Mr. Pritchett and Mr. Robinson. Let me go over the sentencing because a lot of people had questions. It was a lot of math. I believe the state asked for 30 years for Mr. Robinson and 45 for Mr. Pritchett. That was the state's ask, if I remember right. It might have been 35 and 45. But that's what they asked for. It turns out that Robinson will get 30 years, a 30-year sentence, but only has to serve 25. 5 of those 30 years are in, already on probation, already scheduled to be served on probation. And it's possible that there's an earlier probation period as well. And that's a little confusing. But basically, the sentence was 30 years for Mr. Robinson. As far as Mr. Pritchett, the sentence was 40 years with 30 of it is served and 10 on probation. Both of them got credit for time served because they've spent 5 years in jail since this happened. 5 years ago, they were arrested just days after this event. They were arrested and they've been in jail since then. Looking at all this, I can go over the math again, but it adds up. But basically, Mr. Robinson got 17 plus 8 plus 5, and Mr. Pritchett got 20 plus 10 plus 15 plus 5. That's how it works. And basically, the ones that are serving that are running concurrently, that means they all run at the same time. So imagine if you were to start 10 stopwatches at the same time and say each one has to reach 10 years before you can get out of jail. All the stopwatches running at the same time, they all work. If they say consecutive, you don't start the second stopwatch until the first one has reached 10. So in Mr. Robinson's case, the first stopwatch starts and runs until he reaches that 17-year mark. After that, the next stopwatch has to count up to 8 starts. In Mr. Pritchett's case, the first stopwatch goes for 20 years, and then the next one goes for 15. And then 5 after that. So yeah, it's a long time. Mr. Pritchett was already in on a 20 year. He had 15 years left on a 20 that he was serving. So that's going to run at the same time. That's another concurrent time. So he's going to be serving all those 20 years at the same time as that one. So hopefully that confuses muddies the water. That motion that Mr. Pritchett wanted to file at the beginning. Oh, wait. Before I do that, the defense for Mr. Robinson, did you listen to what they asked for? They asked for a 10-year sentence with credit for time served and 5 years probate, which basically means they release him today. That's what they wanted. We want him released today after credit for time served. That's like, whoa, that's far different. I mean, that's literally the very minimum you could ask is let my guilty client go right now and then just serve some probation. And that was not going to happen. But she has to argue, the best interest for her client. So she swung for the fences on that one. It was, as Matt Harris says, bold move, Cotton. Yeah, that was, it was incredible. I heard that. I'm like, whoa, it's a 10-year sentence, 5 served, 5 on probation. He's already done 5. Yeah, that's crazy. I don't know the date on the girls' trial, and I don't know if the girls' trial is going to be with this same judge. But the 2 girls, and we talk about the 2 girls, they're the 2 that testified against these 2 witnesses. They were also co-conspirators in the crime. They are facing their own list of charges, almost identical to these. I don't know if they have gang affiliation, modifiers on there, but they're coming up. They obviously the fact that they helped and testified against these 2 might help them in their case. And I don't know if they're going to run all the way through a trial, or if they're going to take a plea deal or get a deal, but we'll watch for that and see what happens. Amber's going to get the dates for the girls. We'll see what happens. All right. So Bryan Kohberger, we didn't have much time to talk about that. The dates, if you missed the Bryan Kohberger hearing, there was this little surprise hearing that sort of sprung up on us today. And it's a hearing regarding a motion to seal a hearing that was already on the books that we had scheduled. And that was the one that was going to happen on May 14th. That hearing is about a motion to compel, which means Bryan Kohberger's lawyer is filing an order with the court complaining, saying, hey, judge, make them give me something. I've asked for it. I want this. I should have it. You should make them give it to me. It's a complaining session. It really is. If you saw them fighting back and forth in front of the judge, and he's like, hey, guys, children, calm down. We should be able to work this out. It's going to be complaining back and forth and bickering and finger pointing and, well, he said this and this was back then. Well, you haven't done this. And, well, I've done this. Well, we don't have that. It's going to be back and forth, and it's like going to be children fighting back and forth. But the things they're asking in the Bryan Kohberger case are very interesting, are so interesting that the state says we don't want the public to have this information because currently they don't. And the judge has ruled that basically anything that happens in open court becomes part of the record and the public gets it, right? That's how we have all the documents that we have so far. All the previous motions to compel have been public. This one is about some stuff the state does not want public, and the defense wants it public. Not necessarily because of the evidence that's there, but because I think that the defense knows that some of this evidence is not available yet, or it's not really. It's not like the smoking gun type evidence. And if they can put stuff out there that just looks weird and like if they can get the state to say that, hey, we don't have this evidence, we don't have anything, that looks good for Bryan Kohberger in a weird way, that the state is supposed to produce evidence and them saying we don't have anything. They're literally trying to influence the public and swing public perception, saying, whoa, like she said, maybe the state's case is weaker than we thought. Maybe they don't have the facts that we thought they had. So interesting. This little game of chess they play, obviously they've got till September, right? The state has till September to turn over all the things they need to in discovery. And there's some things they don't want to turn over. Some of them are saying, look, we don't have those. We're not planning on using them, so we're not going to give them to you. We're not going to try to get them so we can give them to you. But it's going to be interesting. Defense wants the public to be swayed. I love these battles. I love that the defense pushed Judge to make a decision today. I don't like the decision he made. The decision he made was to basically close the hearing and saying, I'm worried that once the poop is out of the horse, it can't be put back in. We can't just say, oh, wait, you guys weren't supposed to hear that. Okay, everyone leave the courtroom, close the hearing, shut down Zoom, and now continue, because now it's out. So he says, instead, we're going to start with the hearing closed, and if there's something we can open, we will. Guess what's not going to happen? The judge is not going to be like halfway through this hearing, right? As they've worked through the spicy bits and then they get to the dull bits, he's like, hang on. The rest of this stuff, pretty sure the public wants to know. You good with us starting the Zoom up now? It won't happen. We're not going to get that hearing. I'm not holding my breath. We'll watch for it, but honestly, it will literally be us sitting here hitting the refresh button for an hour after the hearing's supposed to start, hoping that the judge just starts Zoom and we get part of a hearing, which is terrible. I don't think it's fair. I don't think that's an open hearing. When you first of all tell the public it's closed and kick them out of the courtroom, and then at the last minute open the doors and say, well, you could have come in. I unlocked the doors. Yeah, you kicked us all out and said it was closed. I don't like that. But let's see. What else do we have? Beating the dead horse. There we go. We got rid of the beating the dead horse saying, and instead say we're thinking about riding a horse down the beach at sunset. Mod chat, says Amber, which means I probably have something to look at here. Just one second. Okay, we have some spicy motions in. Oh, they're big. Hang on one second. In the Treehouse trial, are these? Did you send it twice? Defense objection to state motion in limine. They're both 18 pages, exact same file size. Did you send this one twice, Amber? Because I'll read every word of both of them before I realize it's identical. Amber says, crap, hang on. Did you send the wrong documents? All right. Podcast tonight. Yes, well, you're here. Tonight we have the podcast, the Not Relevant Podcast. It's going to be me. It's going to be Thomas. And it's going to be two of our favorite guests all at the same time. It's going to be panel format. You guys obviously are invited to participate through chat and possibly something else. We'll see. I'm not sure. Not sure if we're going to subject our favorite guests to anything else beyond that. But please do schedule to be here tonight, 8 p.m. Eastern time on this channel for a live podcast. It's going to be a lot of fun. Let's see. State emergency motion. This is Franklin Tucker. Let me see if I can bring this over on channel 3. Inbound document. Let's take a quick peek at Tucker's. We know that I think somebody's calling to explain. Let's see who this is. Hello? Hello? They hung up. We tried. All right, let me take a quick peek at this. Now it's Amber. Amber, it helps if you talk in your end of the phone when I say hello. That the conversation goes better that way.
I got your voicemail.
Thank you.
I'm saying.
I might have hung up on you.
I got your voicemail, so it didn't actually pick it up in time. Anyhow, so the documents that you're looking at, the state emergency motion, that's the most recently filed. That's where you're going to find out that some spicy stuff is happening. And then the defense's motion, that's 18 pages. There are a bunch of exhibits that go along with that. So I figured we could find out what those exhibits that he filed that are hundreds of pages long, what they correspond to, because I'm pretty certain one of them is about one of the state's attorneys and a bar complaint.
Oh, it gets juicy from the get-go. I'm excited.
Yeah.
So
I don't know which one you want to start with.
I'm going to start with the state's emergency motion. First of all, because it has a picture.
Mm-hmm. It does.
And I like pictures. And it's got a link to a YouTube channel, and I like that as well. So I'm all about seeing YouTube channels linked in motions. So I'm going to start with that. We might, if we have time, we might go back and look at the other one. But let's do this. Let's add Franklin Tucker to the playlist for today's live stream, and we'll get this read. Thanks, Amber. Appreciate it.
Not a problem.
All right. Bye. I almost hit the cut button instead of hanging up. All right. Here's where we are right here. If I can make this full screen so I can see it. Let's see. Let's close this one down. There we go. Okay. This is the Franklin Tyrone Tucker case. For those that aren't familiar, this is the Treehouse case, the Treehouse murder case. Hang on, before I do this, I owed Romana DeCisi. I'm not saying that right. Roman ADCC. Roman ADCC. It's right here. You spelled it out for me, and I still can't do it. You say, it's so sad that these kids make so many mistakes so young. Where are their parents? These kids needed some guidance. So sad. I have a son their age. This particular color of Super Chat for some reason doesn't show up on some screens, so I wanted to wait and share that. Thank you very much for the Super Chat. I saw the message when it came in, and I just want to recognize that. Let's see, Cindy Crotchet, sending thoughts, love, and prayers to this mother. This is a nightmare as a mom with 2 sons with mental health issues. And Angela Knox also shared, when you hurt people, there's a price to pay. What is the price? Thank you, Angela. And congrats on 10 months, Angela. Congrats on 3 months for Cindy as well. Amazing, all of you. Now, over here to to our document. Let's read up on the juiciness that is the Tyrone Tucker treehouse murder trial. State of Florida, plaintiff, Franklin Tyrone Tucker, defendant. The state's emergency motion for protective order to prevent extrajudicial comments. They want a gag order. They're asking for a gag order. Comes now Dennis Ward, assistant state attorney for the 16th Judicial Circuit of Florida, by and through the undersigned assistant state attorney, and requests this honorable court to reissue the previous protective order to prevent extrajudicial comments that was imposed on the state and the defense in light of the upcoming retrial on this matter. In support, the state submits, prior to the first trial of this matter and after full evidentiary hearing, the Honorable Circuit Court Judge Jones issued a protective order to prevent extrajudicial, outside of court, comments, and thereafter lifted it once the trial commenced. Upon the announcement of a mistrial, the state requested the court to reissue the protective order on the basis that the defendant has been posting videos, conducting interviews, and making various slanderous statements on social media. The court at that time did not move forward on the ora tennis motion made by state and indicated that it would look into the matter if the appropriate motion was filed. Since the announcement of the mistrial, the defendant has continued to post statements not only about the facts of the case and the activities in the first trial, but also disparaging statements about the state's attorney's office, MCSO, the previous presiding judge, the prosecutors, and the prosecutors that conducted the trial. More recently, the defendant started posting on his YouTube channel, Free Franklin Tucker. Here's the link. Look, there's a picture. The defendant has, this is Franklin Tucker right here. That's his picture, and Lady Justice from Canva. The defendant has indicated he will be giving weekly updates on the status of his retrial and will answer questions posed, which he did in his most recent postings. To date, he has had 4 live updates wherein he discusses the facts of the case, his various legal arguments. He attacks the state, the witnesses, and makes accusations of witness tampering, perjury, and prosecutorial misconduct. He also comments on how he can say anything he wants in the trial because he's not a licensed attorney and the court is not able to discipline him. The defendant has mentioned a new website he will be creating, which will have videos related to the case and documents that were not previously uploaded on his Free Franklin Tucker website. The same website which was the subject of the first protective order. Additionally, according to the defendant, this website will also have an online store with shirts and hats people can purchase to help offset the cost of his legal fees. In addition to his broadcasts on his YouTube channel, the defendant has also sat for interviews on other YouTube subscribers' channels, just like he does in live broadcasts. In the interview that is available for viewing, the defendant discusses the criminal case, the upcoming trial, attacks the SAO and MCSO, and continues to lodge accusations of misconduct. The defendant has indicated that he will continue to sit for interviews that will thereafter be posted online. In the defendant's last 2 live broadcasts, the defendant announced that his wife, Lauren Janai, will be conducting a live interview with victim witness Todd O'Quinn and invited people to watch the broadcast on the defendant's YouTube channel. Despite the fact there is still no contact order in effect preventing the defendant from having direct or indirect contact through a third party with Todd O'Quinn, this interview is expected to take place in the near future. It should be noted that during the last live updates, the defendant discusses the previous gag order and the likelihood that the state will seek reinstatement of the order in light of the content of his live broadcasts and the content he will be uploading. The defendant goes on as far as to boast that he has a response already prepared if the state seeks the gag order again. Most of the content of the defendant's live videos on his YouTube channel is the reason the previous protective order was issued. This new website, the defendant indicated he will have within the next week, in all likelihood, will contain similar material and content which will only serve to taint any potential juror with his prejudicial pretrial publicity. All of the defendant's social media activity pertaining to this criminal case, whether on his own YouTube channel or others, or his Facebook posts, have already created a serious threat to the administration of justice. With this matter proceeding to another trial in the next month or 2, the ability to find impartial jurors who have not heard anything about the case and or have not heard any or read any of the defendant's comments will already be difficult. As was needed previously, a gag order is necessary to prevent the upcoming jury pool from being exposed to any further prejudicial pretrial publicity about this case. To allow the defendant to continue to make comments on social media or any other forms of media will only serve to greatly prejudice the state and the defendant's ability to impanel a jury, not only further, but escalate the threat to the administration of justice. Wherefore, this is what they want. The state respectfully requests this court to impose the previous protective order and to order the defendant to remove all social media posts related to the criminal case since the mistrial. Ooh, they want to retroactively pull down the posts. I do certify, here's a certificate of service, certify the copy is hereunto been furnished to Franklin Tucker by email on the 24th day of April 2024. And that was from the state attorney and the chief assistant state attorney. So most likely, I would say a gag order might be in order. Now, it's different. It's different the second time on a mistrial, right? Because you've literally televised the first trial. It was on TV, right? Everybody knows about it. And now you're saying, wait. Now we need to find another jury. Yes, they still need to find an impartial jury. But putting a gag order, it sounds like, you're trying to refill that toothpaste tube after it's all been squeezed out. I don't think that works very well. But it might still be ordered. I'm not sure. What do you think? Are they going to make him pull down all his media posts? Do you think they'll do that? We haven't talked to Lauren in quite a while. Let's see. Let me see if... I'm not trying to call her right now. I'm just saying, trying to find the other documents that we were looking at. Send that over here. Bing. It's arrived. The second document, this one actually came first in the timeline, is the one filed by Tyrone Tucker. Defendant's response in opposition to plaintiff, State of Florida's motion in limine. I see we've got the Facebook screenshot. I see that in there. I wasn't going to show that one. Wait. Okay, hang on. Let's send this one. Save the picture. I'm going to see if I can pull up the screenshot from the Facebook post really quickly. Where's it at? Bring it over. Come on. Well, apparently I can't show this one to you. I don't know why. Well, I might read it first. Let me first do this. Franklin Tucker posted, I believe, when was this? It shows 21 hours ago. Was this a screenshot taken today, or is this a couple days old? Posts on Facebook and says, to all, I guess I was wrong about the judge since he just issued a warrant for my arrest for supposedly missing a UA that I did not miss. I went and was told I couldn't take the test. Pretrial even checked with the facility to find out the issue, and then I took the test. But now I get a warrant while in compliance. To make it even better, he wants $3,100,000 bond to keep me out of jail. Even if this is a mistake, it doesn't matter because I'm sick to death of being treated like a criminal and having to worry about going back to jail whenever I fart and cough. But these... I'm trying to tone it down. What's a good word to replace that? Yeah, I can't say that. These people, with no evidence, lied to the jury blatantly on national TV, and yet still months later, it has yet to be addressed. Maybe if they hadn't lied, I wouldn't still be on pretrial release, which I should have never been on in the first place, but this move is absolutely ridiculous. Right now, I'm not sure how I want to handle this because it's obvious that this guy is going to be just as bad as the last, and I refuse to be railroaded into a crime I did not commit by a bunch of corrupt people who wiped their hiney with the Constitution. So I guess this is a reality check on getting any kind of fair trial in Monroe County. Furious is not the word for what I am right now, and it looks like my only hope is if enough of you file a complaint with the Department of Justice, who have already accepted my complaint, but seem to be sitting on their behinds and letting this go down. So here's the link to file a complaint and my report number, and he gives the report number. Please tell them what you've seen and what is happening, and thank you all for supporting me in this fight. I'm sorry, we'll try to do another video so we can talk about before they arrest me, but I need to finish filing a few things and prepare to be returned to jail. I honestly can't believe this is happening to me, but maybe the DOJ will do something if they get enough people telling them how wrong this is, because it sure as heck ain't justice. Love y'all, Ty. So, bass fishermen, that's what it was. Bar stewards, thanks for the substitute buttons. The beep button is too loud. I need to turn the volume down, the beep button. Let's see. So looking at this, I think our Airbnb guests finally arrived. Hang on. I'm gonna check and see. Yep. Cool. All right. Can we see the page? I can't get it. Just go over to my screen that I'm able to share it to you on. And it was just a screenshot. I didn't even see the page it was on. So I have to look at that. UA is a drug test. Yep. Urine analysis. That was 22 hours ago. I'm debating reading this, but I'm also hearing drama outside. Not like outside, but with my kids. Can you guys hold on for just a second if I let you know what to show you? Let you listen to some music. How about that? I'll be right back. Just 1 second. So my cat is back. My cat is back, laying on the deck like it owns the place. What did I miss? Sorry. My cat gets into fights. I say my cat, but I guess the neighborhood shared cat gets into fights. And I think I know why he was gone for a couple days. I can tell you, because the cat gets into fights and got injured, and it came back, and the injuries are all stitched up, and it's like been shaved in the areas where it had this. So it's been at the vet. Clearly, it is clearly more somebody else's cat than it is mine, because it's been taken care of quite well while it was gone. I didn't know it had been injured, but it's got a bunch of injuries that have all been stitched up and treated. Anyway, so that's the update on the cat. I see what you're doing there, CBD. Yes, red wolf. We have a red wolf in the neighborhood, which we're super excited about. I don't think he was ever broken, AVX. Yeah, he's been modified. He's been modified. I think he probably has 3 families right now, is my guess. All right, where were we? Do you want me to read the 18 pages from Tyrone Tucker on the motion in limine? Do you want to do that, or do we want to? I'm seeing some yeses. See if we can bring this up. Why does it look so funky? Let's open in preview instead. Let's close this. Close that and bring it over to this one. I like this view better. There it is. All right, can you guys read? You guys see all that? All right, here we go. Got a few pages here, so I'm going to take some water breaks periodically. But this is the defendant's motion in opposition to the plaintiff, the state of the Florida's motion in limine. So the state wants to eliminate something from eligible evidence or from being brought up during the court trial, and this is the opposition. So here comes pro se defendant Franklin Tyrone Tucker. Hereafter, Tucker fires over the bow, files this response in opposition to the state's motion in limine, as their stated causes are neither factual, nor does the state attorney give a sufficient legal argument to warrant granting such an order. The defense would argue that the court made significant errors at trial, including not allowing the defense to inquire about the investigation, the tampering with evidence, or the misconduct committed by the state attorney, Dennis Ward. Oh, this is already starting great. Hereafter are members of the state attorney's office, hereafter SAO, members of the Monroe County Sheriff's Office, hereafter MCSO, Rick Ramsey, hereafter Ramsey, and even the Honorable Judge Mark H. Jones, hereafter Jones. He's just going to refer to the judge as Jones. Throughout the entirety of the case, instead of referring to him as like Your Honor or the court or something like that, he's just going to be like, Jones did this. Okay, this is already serious shade that's being cast here. So throughout the entirety of this case, furthermore, Mr. Ward has yet to even reconcile the gross misconduct committed by his assistants at trial. Those actions were more than enough to warrant ASA Joseph Mansfield, hereafter Mansfield, ASA David Alvarez, hereafter Alvarez, and Mr. Ward to be disbarred from the practice of law. Instead, he expects this court and the defendant to ignore what happened and the damages they caused to not just to Mr. Tucker, but to the integrity of the entire 16th Judicial Circuit. He has the audacity to think he can rush this case back to trial, foregoing any sanctions or relief the court would deem necessary to ensure this behavior is not recurrent. The fact that he would do so by further insulting the integrity of this court with a motion that states causes he knows to be false. Oh my goodness. That's a serious allegation. In and of itself, be enough for the court to consider using its discretion, foregoing in the defense's upcoming motion to dismiss and immediately vacate the charges against this defendant, with prejudice, I'm guessing. That by continuing to be deceitful in his deeds and untruth in his statements to the court, Mr. Ward has already displayed enough bad faith in this prosecution to warrant such an extreme measure. While this is the defense position on the matter, if the court is unwilling to take such actions, the defense would only request that the court offer some sanctions or relief, as it deems appropriate, to prevent further damages to the defendant and to the entire framework for the justice system of Monroe County. In addressing these issues, the defense would first like to offer individual rebuttals to Mr. Ward's causes, establishing such bad faith, and then conclude with additional facts that would support this court, without motion, dismissing the charges against the defendant with prejudice. That issuing such an order would be in the best interest of the justice for the defendant, for the county, and for preserving the integrity of the court. So here are the rebuttals to the state's motion in limine. Need more water. Page 2. I'm missing chat here, sorry. Oh, let me know which exhibits you want to correlate to this pleading. You said there are hundreds of pages. I'm not sure if we have time to go through all those because we have other court to watch this month. But we'll try. The state misrepresents the defendant said at trial and produces no transcript, video, or other evidence even to make such a claim. However, barring their misrepresentations, the defense did attempt to call Tom Walker, hereafter Walker, to the stand. I like he just uses last names, to the stand to inquire about his investigation and the fact that he sustained 207 pieces of mishandled evidence in this case. Had the defense been allowed to question Mr. Walker about his report, the jury would have heard, and the court would have learned that the report fails to mention any of the evidence already known to be altered and or destroyed. Since Mr. Walker was the investigator and is presumably aware of the evidence that has been tampered with, the defense had a right to question why these pieces of evidence were not included in his report. The defense also had a right to know if he has any information about the extent of tampering, how many pieces of evidence have been altered or destroyed, and who was responsible. Mr. Walker's position and his investigation could have potentially given us some of those answers, or at answers as to why the MCSO is refusing to investigate the evidence tampering that is known to have occurred. The defense could have also questioned Mr. Walker about the failure to collect and preserve evidence that would have been exculpatory to the defendant. Those failures, which could have exonerated the defendant, not only raise questions of reasonable doubt, but there is case law that states this infraction alone is denial of due process. When identity is an issue at trial and the police permit the destruction of evidence that could eliminate the defendant as the perpetrator, such loss in material to the defense is a denial of due process. And he cites a Supreme Court ruling, Arizona. Let's see, State v. Youngblood. I don't know that I'm having a hard time reading those. I'm not really good at citation readings. Unfortunately, the court erred in not allowing Mr. Walker to testify, which is yet another violation of Mr. Tucker's due process rights, an issue the defense will address further in our response. However, unless Mr. Ward can come up with a legitimate reason as to why the defendant's interview videos have been chopped up into nearly 80 different pieces with sections that are missing, then it is self-evident that the videos have been altered and that these are not the only videos that were. The state became aware of who altered Rory Wilson, hereafter Wilson, interview video during his trial. The defense has inquired for years about the missing 3 minutes of video immediately after Mr. Wilson questioned, "If I say Ty done it, I get to go home?" He testified at his trial that former NCSO Captain Penny Phelps, hereafter Phelps, turned off the camera and then threatened to arrest his 8-month pregnant girlfriend if he didn't give her a story. While it may not be obvious to Mr. Ward, the defense had long surmised that it was something along those lines. Did the state think it was just coincidence that when the cameras turned back on, Mr. Wilson suddenly gives Ms. Phelps a fictitious story about the defendant planning the robbery? A story that even MCSO lead detective Pitcher, hereafter Pitcher, stated he knew was false at the time? If the state believed Mr. Wilson's story, then why were the fictitious co-conspirators never investigated or sought for questioning? The answer is because they knew he was lying. Even though Mr. Ward knew or should have known the story was a lie, he still decided to prosecute this defendant based on nothing but lies. Given the lack of candor about the investigation and Mr. Ward's decision to prosecute originally, much less his decision to prosecute now, the defense questions if Mr. Ward or any other members of his office are even capable of the truth. We will further reserve further testimony from Pitcher for the second half of our response, but it is important to note that his testimony not only affirms that digital evidence was tampered with, but lays the blame for that tampering with the state attorney and his office. Number 2, the state again misrepresents the facts and blatantly lies as the judge never asked the defendant to provide any proof that evidence had been tampered with or that we would have gladly presented him with our findings. No, the court again erred by declaring Mr. Walker's testimony irrelevant without even listening to the defendant's reasons or giving the defense any opportunity to show such evidence. He simply denied the defense the ability to call the witness among others. As for Tom Walker's list, the defense should have had no need to provide to the state, considering they entered Mr. Walker's report into evidence just prior to trial. The defense should note, though, that Mr. Walker's report was not entered in by the state in its entirety, and there are pages missing. But since the state never introduced it at trial, the defense made no objections. Had the defense been allowed to call this witness, we would have corrected their oversight. But as it stands, the state and Mr. Ward had the responsibility to ensure they had a complete copy of the report prior to entering it. The defense is being kind when calling it an oversight. And Mr. Walker was working for the SAO when they entered his report, so they could have easily verified its completeness. The fact that they entered it incomplete should be seen as just more deception by the state, probably to avoid questions about the same list they now falsely claim was the responsibility of the defense to provide. See these exhibits. The defense has already addressed this fabrication, as they didn't just obtain a copy of the list. Mr. Walker's report was entered in as a supplemental discovery by the state. Furthermore, since the judge ruled that the defense could not call Mr. Walker, the defense had no responsibility to provide this list to the state. The defense has also already addressed this issue. However, while Tom Walker's report doesn't specifically state that any of the 207 mishandled pieces of evidence were tampered with, had the defense been allowed to question Mr. Walker, we could almost guarantee the court that his answer to the question if any of the evidence had been tampered with would have been, "I don't know." We can state this with such certainty because we know the scope of the investigation did not include Mr. Walker even attempting to ascertain if any of the evidence was altered, and only touched on brief explanations as to why they were mishandled in the first place. The answer, "I don't know," that we expected may be good enough for Mr. Ward and the state, but it is not nearly good enough for the defendant facing a life sentence. It is also false that evidence on that list doesn't pertain to the defendant in this case, as his buccal swabs are listed, as are some of his personal belongings, clothing from Matthew Bonnet, and plenty of audio and video recordings that were suspected to have been tainted by our investigation and were used again against this defendant at trial. He wrote this sentence poorly. That were suspected to have been tainted by our investigation. I don't think he means tainted by our investigation. I think he means that by our investigation are suspected to have been tainted. Phraseology, it's important. The defense has also already addressed this misrepresentation, as the state is either ignorant to the facts of the case they are prosecuting, or they are just bold-faced lying. The defense will happily provide the state with a list of evidence that is known or suspected to have been tampered with or destroyed, but as previously stated, much of it is self-evident. That while the defense is willing to create and provide such a list, it is extremely frustrating and infuriating to think that after 6 years of pretrial discovery, where these issues were repeatedly brought before the court and to the attention of the state and the defense, would now be required to educate Mr. Ward and the state on the nature of its own evidence. Evidence that Mr. Ward has used to maliciously pursue prosecution against the defendant, when he should have known the facts before ever even filing the information or seeking an indictment. The truth is, he does know, and he knows the facts don't support and never did support his decision to prosecute the defendant. The defense has run out of patience dealing with the lies and fabrications that have been put forth by the state throughout the entirety of this case. It is not only offensive to the defendant, but it's a mockery of justice, and the fact that Mr. Ward is even suggesting the evidence wasn't tampered with only shows the extreme level of dishonesty and self-interest in this man and the prosecution of this case, considering almost all of the tainted evidence leads right back to the SAO. Okay, so this is written by Mr. Tucker, who is not an attorney. And had this been written by an attorney, there could have been sanctions involved. There's some stuff in here that attorneys aren't allowed to say. It's just wrong. You can't do that. But because he's not an attorney, he gets some leeway. He is a pro se defendant, and he gets to sort of, the court is supposed to recognize that a pro se defendant is not Harvard educated, law student graduate with years of practice, and they do allow a little bit of leeway to help them out a little bit. Yeah, I don't think this will be successful. I don't think it will. While this is unnumbered, the defense wanted to make the court aware that the state motions currently being considered were never sent to the defense. The defense only became aware of the filings because we regularly check the docket posted online by the clerk's office. The defense again feels this wasn't an error because their filings all attempt to hold the defense to a 10-day response time they're assuming the court will grant while filing a significant amount of requests all at once. We are aware no rules prevent the court from ordering a 10-day limit or prevent them from filing their requests as stated, but there are rules about sending copies of filings to the defense at the time of filing. The state has been in possession of the defendant's email address for a long time now and has sent previous filings to that address, so we would request that if the court decides to allow the case to continue, could it please remind the state of its obligation to send copies of any future filings to the defense? That was just a late insert. In bold, all in bold. Defense position on tampered evidence, the investigation, misconduct, and the continued dishonesty of the state attorney and SAO. The Fifth Amendment's Due Process Clause states that no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment also provides due process protection from state action by declaring that no state shall deprive any person of life, liberty, or property without due process of law. Similarly, Article 1(9) of the Florida Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. The fundamental requirement of due process of law is the opportunity to be heard. Case law. The opportunity must be full, fair, and not illusory in nature, so it's not an illusion. It is a denial of due process when a party is not afforded a chance to fully present his or her case, including defenses. The defendant's due process rights were violated when the court deprived him of the opportunity to be fully heard in the presentation of his defense, his witnesses, and evidence. Specifically, the court made significant errors by forbidding the defendant to inquire about the quality of the investigation and the tremendous amount of misconduct that has been committed on this case by members of the MCSO and the SAO and by the judiciary and by the court. The court also erred when it did not allow, I think it's supposed to be erred, but he wrote erred there, when it did not allow Seth Levy to authenticate the motion to suppress filed by Mr. Levy on behalf of Johns Travis Johnson, hereafter Johnson, as it was a public document and not subject to the attorney-client privilege and could be used unlike the state suggested, and the court ordered to refute the statements made by Mr. Johnson with his previous inconsistent statements in that motion under Federal Rules of Evidence 801, exclusions to hearsay 2C. The fundamental principle of due process of law demands notice and an opportunity to be heard before a final judgment is entered. The state and Jones made broad and sweeping assumptions concerning, Jones is the judge, by the way, remember that. The state and Jones made broad and sweeping assumptions concerning the relevance of testimony, lines of questioning, and evidence to be submitted by mistakenly declaring the investigation was irrelevant, just as the state again attempts in this motion. The defense has used quotations around its chosen words such as errors and mistakenly because the defense truly believes these miscarriages of justice were not the products of negligence, but much like the state's current motion and notices, they were calculated attempts to silence the defendant. The only purpose of which and purpose in this prosecution is their attempt to conceal the nature and magnitude of their own misdeeds. He's not pulling any punches here. The criminal defendant has a Sixth Amendment right to present his own witnesses to establish a defense. The defendant was denied the ability to call witnesses, such as Mr. Walker, to establish his defense based on the same misperception of relevancy and assumptions about the line of questioning. More importantly, defense believes it wasn't allowed to call these witnesses because they would show the MCSO and the state had attempted to manufacture evidence in this case previously. We also believe that the testimony from these eliminated witnesses would have bolstered the testimony already provided by former Detective Pitcher. Testimony that would indicate the members or former members of the SAO may actually be responsible for the evidence tampering that did occur in this case. As far as the relevancy of the investigation and the misconduct, it is clearly established that both are relevant to any criminal proceeding and that the government must be able to make its claims based on evidence that hasn't been fabricated or manufactured, altered, or tampered with, misrepresented, and only under limited circumstances is allowed to use evidence that was obtained illegally. Without being able to inquire about the investigation or the sustained misconduct in this case, it would be impossible to show the truth behind the government's actions, and furthermore, it allows the state to claim anything as evidence without any means to verify the validity of the evidence they are presenting. This is neither consistent with due process or the truth-seeking functions of a trial. As of 1959 or earlier, it was well established that the defendant has a due process right to be free from false or fabricated evidence that results in his conviction with case law. Those charged with upholding the law are prohibited from deliberately fabricating evidence, defining a constitutional right not to be deprived of liberty as a result of the fabrication of evidence by a government officer acting in an investigative capacity with case law for that. A conviction obtained through the use of false evidence, known to be such by representatives of the state, must fall under the 14th Amendment. The state is very aware that there was significant tampering done with digital evidence in this case, which goes above and beyond Mr. Walker's sustained mishandling of approximately 207 pieces of evidence documented in his report. As was previously stated, many of the videos that were tampered with are self-evident, such as the defendant's interviews done with MCSO detectives that were edited into approximately 80 different pieces with portions missing. This should never happen. However, the state neglected to mention that Walker's report also stated that many videos were missing from the case file at the MCSO, which means they were not entered into evidence or they were deleted, but either way it breaks the chain of custody that these videos has to be recovered from the SAO. Some of these videos were used at trial. The defense has yet to file a motion to exclude this evidence because we believed some of it to be exculpatory in nature and other exculpatory evidence has either disappeared or was not collected at all. In the latter situation, we believe it was done completely in bad faith by the investigators, as more evidence such as forensic evidence that could have been found or not found could have been exculpatory to the defendant by proving he was never in the vehicle alleged to be used in the crime. The MCSO failed to impound the vehicle and only searched for it for physical evidence prior to its disappearance, thus negating the chance for the defense to inspect the evidence. The defense has never heard of another homicide case where a vehicle was used but police failed to do a forensic search or impound or search for the vehicle for evidence. I bet we could find one, though. The defense will not rehash the state's knowledge of Wilson's testimony at trial, except to add that Wilson recanted his statements about the defendant during his testimony, yet the prosecution still allowed their witness, former Detective Danielle Malone, to perjure herself on the witness stand by saying Mr. Wilson's statements combined with Mr. Johnson's are what made the defendant a suspect. The state knows that the testimony was false because of the so-called hot mic tapes that were recorded exactly when and how Mr. Tucker became a suspect. It is also important to note that John Travis Johnson also recanted his statements about Mr. Tucker prior to the state cutting him a deal, but the prosecution and Jones improperly kept his motion to suppress out as impeachment evidence. Jones didn't allow it because it was only evidence. It's the only evidence the state had, which is another issue we will address in our forthcoming motion to dismiss, as it amounts to a subornation of perjury. This federal crime goes beyond the loss of license by the bar and can result in a prison sentence of up to 5 years if Mr. Mansfield and Mr. Alvarez were charged by the state for witness tampering under federal law. The penalty could be increased to life imprisonment due to it being conducted on a capital case. Wow. He's saying the prosecutors should be serving life in prison for what they did. Let's see. We do have this case on our. If you look for the Treehouse Murders playlist, you'll see this case. It's no mystery as to why the state would request that testimony about tainted evidence not be presented to the jury, considering in his deposition, when Pitcher, the lead detective, was asked about missing and altered videos, he testified that he gave unrestricted access to the raw digital evidence to former ASA Colleen Dunn, hereafter Dunn, and also testified that the SAO had direct access to the body camera footage on a different system. Chain of custody exists to help prevent tampering, and especially allegations of tampering by the prosecution. Unfortunately, Dunn seems to be a product of Ward. since she specifically requested this access from Pritchard and was suspended by the bar for her lack of candor in this case. It's also important to note that she was suspended just prior to that for dishonesty to the court and withholding evidence in another case. The defendant's wife also had a case pending before the bar that would have seen Mrs. Dunn lose her license permanently for further misconduct on this case, but the case was closed due to improper comments from Jones. She will be refiling those charges, and we will also be filing additional complaints against Mr. Mansfield, Mr. Alvarez, and Mr. Ward after the completion of this case, along with the Judicial Qualifications Commission's complaint against Jones. I didn't know Lauren had a case. Pitcher also testified concerning his unrestricted access that he didn't think it would allow her to edit and delete files, but that he would need to check with their IT department. The defense believes Pitcher's thought to be wrong, even as the word unrestricted would denote all access, and the very nature of Pitcher's job would require that he be able to add or remove files from the main case file. The defense also presented a text to Pitcher during his deposition that came from Dunn asking Pitcher to remove the restrictions on the files, and this message made clear this access was being utilized by other individuals at the SAO. Pitcher verified the contents of this message and nature of it, and he ultimately gave them this access. While it is alarming that Dunn and others at the SAO gained access to the raw digital evidence in this case, especially evidence where we know files were edited and deleted, it is even more alarming that he testified that by giving her unrestricted access, it wasn't only good for the treehouse. It wasn't only good for the treehouse case. It was good for every case in Monroe County. He's now called into question the legitimacy of every case in Monroe County that they have access to. So yeah, I think Song Chef, this might be why they want a gag order. This is nuts. This is absolutely crazy. Christine Poist was the ASA at that deposition. She has since moved on to the public defender's office, but if the defense were to issue a subpoena to Ms. Poist, we highly doubt she would testify that she failed to tell Mr. Ward about Pitcher's testimony, especially since immediately following that deposition is when the state sought a gag order against the defendant and his wife. Mr. Ward may have forgotten Pitcher's testimony, but the defense has not, or the other legal things that Pitcher swore under oath were done by members of the SAO in the prosecution of this case. Illegal things. The state, to date, there has been no supplemental from the SAO about any results from any investigation into the serious breach in the chain of custody and the possible countrywide tampering with evidence by the ASAs, but considering the MCSO is refusing to investigate this breach of the digital evidence that was tampered with, the defense would have to assume that the county-wide implications are extensive. As was previously stated, MCSO never answered to the question in Mr. Walker's investigation about the missing and edited videos. So to date, we have no idea how much or what of the digital evidence in this case was tampered with, but we do know some of it was due to Pitcher's testimony, and now Mr. Ward's complete denial of its existence. The SAO would be the prime suspects for the who and how. This would mean it was sanctioned knowingly by Mr. Ward. He's got so much in here. On October 25th, 2023, the defense sent an email to Captain Lee Ann Holroyd, who is the head of the Internal Affairs Department, hereafter IA, at the MCSO. In that email, we asked that their cases from the Treehouse investigation be updated to reflect current information, that the case be reopened in order to resolve the criminal charges associated with that incident, and the IA gave us an answer to who, when, and what files, and IA give us an answer to who, what, and when and what files from the digital evidence in this case were altered. The defense also pointed out that it should be a relatively easy question to answer for their IT department. However, we received an email from Captain Holroyd on November 2nd stating that cases are closed and no further investigations will be conducted. In an abundance of caution and prior to filing a complaint with the Florida Department of Law Enforcement, the defense sent an email to Lieutenant Colonel Scabilia, who was the direct supervisor of Captain Holroyd, on February 21st, asking him to verify that the MCSO was refusing to investigate the crimes committed in this case and the destruction of the tampering with evidence, destruction and or tampering with evidence in this case, potentially the many other cases in Monroe County. It is significant to mention that Lieutenant Scabilia was also another witness that Jones refused to allow to testify at trial. That email has yet to be responded to by the Lieutenant Colonel. The defense will be filing a complaint with the Florida Department of Law Enforcement and adding it to the complaint already accepted by the Department of Justice. But given how crucial the information is to this case and to Monroe County as a whole, the defense has decided not to wait for the other investigators, especially when this defendant has been waiting almost 7 years at the risk of his life for the answers to these questions. So the defense is going to request the clerk issue subpoenas to the IT departments at both the SAO and the MCSO for their logs on who accessed the main case files, when it was done, and what was done with the files when they had access. To be clear, we are not attempting to gain access to any work product that the SAO may have stored in their systems, but we do want the logs showing the aforementioned information, and it is well within the scope of the information the SAO would be required to turn over as possible exculpatory evidence under Brady. I think he anticipates a gag order and has to get this out right now before things are, maybe filed under seal or something. I don't know. Before concluding, the defense wants to make the court aware that when Ward makes the claims the defense is trying to prejudice the jury by truthfully mentioning tainted evidence that it wasn't the defendant who got caught lying to the jury about the evidence in this case, the bias Jones had against the defendant weighed heavily in his decision-making throughout the entire case, but no more so than allowing the jury to deliberate and make their decision based on proven lies told by the state. Even with those lies, the jury still came back hung, and now the state comes to the court with more lies, asking to silence the defendant about the truth again. The trial was an embarrassment that harmed the public perception of the justice system in Monroe County, but the defense would like the court to consider how continuing to allow this dishonest prosecution makes any sense towards repairing the damage already caused by corrupt officials. How does allowing any more misconduct, even if they could convict, bring integrity back if they have to lie to win? Then there's also the other cases in the county to consider. What happens to the other cases where the SAO used that access? Because if it allowed access to all of the cases and it was used by more than one person, then it stands to reason that they did it in other cases, convicting people with altered evidence. The defense will submit our motion to dismiss after we have transcripts from the trial, but it's just more piled on what they've already shown the court with this motion. So the defense would ask the court to please use its discretion in the interest of justice, in the best interest of the county, and in ending an almost 7-year ordeal for an innocent man. And if the court finds it cannot, please offer some relief that ensures this defendant will at least get a fair trial. Wherefore, the defendant, Franklin Tyrone Tucker, respectfully requests that this court deny the state's motion in limine, dismiss the charges with prejudice, and or any such other further relief as this court deems just and proper. I hereby certify that a true and correct copy of the above was furnished via email or e-service to all attorneys of record on this 15th day of April. Signed, Tyrone Tucker. I think, is there anything? Oh, that's it. So yeah, that case is going to be a fun one. It's going to be a fun one. Rona, here's the gist of it. Tyrone Tucker thinks that the system is corrupt, the evidence was tampered with, and that not only should he be the charges against him dismissed, but pretty much everybody involved should be in jail, except for him. And he's basically saying that it looks like the way this next court is going, the same thing's going to happen. So he's just putting it out there. They can retry as long as the jury didn't reach a verdict of not guilty. Once the jury's reached a verdict of not guilty, then double jeopardy rules apply. He needs to lawyer up. He still thinks that he's his best lawyer. Tucker is a smart guy. He's probably one of the best pro se defendants we've seen. Fire truck. But I think he has some counsel that's almost acting like standby counsel that's helping him out, especially on his filings. Okay, guys, it's 4:30, and I am super sleepy because I was up very late building a bathroom. So I think we're going to wrap up for the day here today. I don't know of anything else that's urgently pressing on our schedule as far as what is live. I think we're good. Is everybody good with taking a break for the rest of the evening? Podcast tonight, yes. Podcast is at 8. Did prosecutors say why they won't go over the Kelly trial? They only said that due to the unique circumstances surrounding this case. I think those unique circumstances have to do with the fact that our evidence is very poor and the investigation was shoddy, added together with the high cost of retrying this case and the fact that only one juror believed us last time. I think that all adds up to why they won't try the case again in the Kelly situation. No naps, just going back to building. But our guests are here. Our guests are here, so that's cool. Yes, we do a podcast. What's it about? Home renovations? No, that's a regular show. The podcast is not relevant. Rona, no, I didn't know why you needed to apologize to me. Okay, we're going to hurry and end it before we get 700 likes. We've got 699 right now, so that's a good spot to wrap it up. All right. Oh, man. Happy Friday Eve. Tomorrow's Friday. Tonight is the podcast, 8 o'clock tonight. It's going to be great. Please don't miss it. We've got some great guests you've met before. You know and love them. Well, there we go. We hit 700. We did it. Thank you. 709. Oh, we're flying. It's going to be fun. It's going to be fun. Bring your wit, bring your sarcasm, bring your humor. It's going to be not relevant, and it's going to be a lot of fun with a 4-panel, a 4-box is what we're going to do tonight. So it's probably going to go off the rails, is my prediction. It's going to go a little bit scawampus on us. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again tonight at 8 p.m. for the podcast. Need more water. All right, we'll see you guys. Have a good one. Be good to each other, and see you tonight. Bye-bye.
This is not Burger King. People do not get to have it their way. Is that crap?
I was kicked back, taking it easy.
Because he was the guy. Somebody just sent me a video of roaches fighting. I don't know who won.
Have them send someone with more experience.